for being here on a Friday afternoon. We appreciate that. Um, we have a couple of, we have three of our members are currently at a county delegation meeting and will be here later. So we will take no official actions on any bills until we have a quorum, if we do take any official actions today. Just another quick announcement in the announcement for this subcommittee meeting. HB 608 was listed. That was an inadvertent error administratively. We won't say who made the error, but it was already exec, and so we will not be reviewing that any further under the committee. We may mention it in the context of another bill perhaps, but it will not be reviewed or acted on by the subcommittee. And then I think I will wait on any more announcements until the rest of the subcommittee gets here. But what I'd like to do at this moment is discuss Bill HB 289. It is regarding domicile qualifications for voting. And I was informed that our friends from the ACLU, Mr. Clementowitz, has a few comments pertinent to this bill, and so he graciously agreed to come up and testify on that at this time. So, Mr. Clementowitz, I invite you to come forward and feel free to speak to House Bill 289. It has a few aspects to it, talking about whether or not domicile might be claimed if someone is a legal dependent under custody at an address outside the state of New Hampshire, and has some other aspects regarding domicile and residency as well. And just for those listening, just be reminded that domicile is essential to voting in New Hampshire. You must have domicile in New Hampshire to vote. And you also are, once you do make such a declaration, either through registration or voting, you must fulfill the residency requirements as well, but also advise people that you can have multiple residencies, such as some of our snowbirds have. And so with that sort of brief introduction, I invite Mr. Clementowitz to provide us with your usual insightful testimony, if you would, please.
Well, thank you so much. For the record, my name is Henry Clementowitz. I'm the Deputy Legal Director at the American Civil Liberties Union of New Hampshire. I want to start with expressing my profound appreciation for the subcommittee for allowing me to testify at this time. Just very greatly appreciated. So I have a few remarks that I'm going to keep pretty short. I think that there's two, and I'm going to talk just about the changes about legal dependents who are can be claimed outside of the state. And so I think there's two issues with this that I wanted to raise for the subcommittee, one constitutional and one practical. So the first constitutional issue is that it's really not, so I understand this bill to be talking about, when it uses the word dependent, to be talking about that from a tax perspective, in that because I'm not aware of that being used throughout the New Hampshire statutes otherwise. So I understand it to be, if a person is claimed on the taxes of their parents as a dependent, and those parents reside outside the state, that the person won't have domicile in New Hampshire, even if they otherwise meet the qualifications. And so from a constitutional perspective, the problem I see is that you are conditioning someone else's right to vote on the actions of another, which is their parents. And it's not up to, like, when I was a child, my parents, I think, claimed me on their taxes as a dependent. I don't know whether that continued when I was throughout college, but it wasn't up to me. They didn't discuss it with me. And so if my right to vote were dependent on them claiming me as a dependent for taxes or not, I think that's an unconstitutional condition to put on someone else's right to vote, because the other qualifications that we talk about in terms of domicile are really within a person's control. So you choose to live within New Hampshire to establish a physical presence, and you choose to make it your primary place for engaging in civic self-government. But in essence, what this is doing is giving your parents a veto over whether you can vote in New Hampshire. So say, for example, a person, were a registered Republican and wanted to vote for candidate A, went to college in New Hampshire, but their parents were Democrats and didn't want their child voting in New Hampshire, they could stop them from doing that by claiming them on their taxes under this bill. And so I think that's an unconstitutional condition. From a practical perspective, I think this is in some ways even a bigger issue, insofar as tax returns are confidential by statute. And so there's no way of anyone knowing, as far as I'm aware, whether this has happened or not. So if I wanted to know whether my parents claimed me as a dependent, I'd have to ask them. They're under no obligation to tell me. They could tell me the truth or not. And unless I, were able to somehow subpoena their tax records, I'd be sort of at a loss as to whether or not I am in fact claimed as a dependent, because I don't, as a minor or as a dependent, necessarily have access to their taxes. In addition, the state authorities wouldn't necessarily either. They may, the DRA will have access if the person is paying New Hampshire taxes, although we don't have an income tax anymore. But the DRA or the Attorney General's office or the supervisors of the checklist are not going to have access to the parents' IRS returns. And so there's no way for that to be enforced either. And so you're kind of putting the potential voter in a catch-22 of, they can ask their parents whether they're being claimed. They can ask their parents not to claim them and sort of hope that their parents don't claim them if asked, or respond truthfully. But short of like actually meeting with your parents' accountant and getting them to waive confidentiality, there's nothing that the voter can do to ensure that they're voting lawfully, because they may not know. And there's really no way for the state to know whether the person is voting lawfully either, because they're not going to have access to the parents' tax returns. And if the parents are residing out of state, as I'm saying this, I'm realizing they're not going to be paying New Hampshire income taxes anyway. They're going to be paying another state's taxes. And so there wouldn't be DRA records. So those are the issues as I see them. There's sort of the constitutional issue of conditioning a person's right to vote on the actions of their parents. And then the practical issues of like, all of this is confidential and how does anyone know? So those are my concerns. Again, I really appreciate so much the actions of the chair and the full subcommittee for allowing me to testify. And I'm happy to take any questions if there are any.
Thank you, Mr. Clementowitz. Representative Burnham, do you have any questions at this time?
Thank you, Mr. Chair. I appreciate the explanation. I don't have any questions at this time, though. Thank you.
Thank you. I do have some questions. Fortunately.
And now it seems like the perfect time to mention that I am not a tax attorney.
Right.
Right. Okay. And so I will do my best to answer, but people should not be operating under the illusion that I know anything about taxes.
In looking around the room, I do not see any tax attorneys, so I
Right.
think we're all in good company.
Great.
No offense to tax attorneys, but so let me just ask this question, if I may. If the person is here in New Hampshire, is truly a dependent and is only here under the sustenance of the parent or guardian, and they are in fact controlling that person being here by that sustaining resources, does that change your opinion on any of this?
So it's a great question. And I think the answer is no, but I'm thinking as I'm speaking. So I'm going to do my best. So first, I'm not, as I said, a tax expert. And so I'm not sure if that's really what's required for a person to be claimed as a dependent under the tax code. I did a little bit of brief research, and
If I may, I'm not a tax person, but I believe the law or the language on the tax forms is something of supplying more than 50% of the wherewithal,
Yeah.
or equivalent for a person. So if that person is in fact living in New Hampshire and the parents or guardian are living elsewhere, then, and now, especially because of the healthcare through the Affordable Care Act, the requirement to support healthcare coverage up through age 26.
Right.
So those aspects, I think, come to bear on this. So I'm to echo your sage words. I am not a tax accountant, but I am familiar with those aspects. And so, a person who is a dependent is ostensibly more than 50% supported, and I think it would be logical to conclude that in fact their ability to be in New Hampshire in a place separate from their parents and guardians, and with the parents and guardians also claiming them as a dependent. Again, some coordination and communication needs to occur in order to have that. But in fact, that person is here on volition of the parent or guardian. So what are your insights onto that?
So a few things. So I think a common scenario of people that we're talking about who are of voting age who could be claimed for are students. And I think that there are special tax rules for choosing students. And so I think a common arrangement, it involves a student and parents co-signing loans for tuition is a frequent. And so whether that is enough of a financial contribution to claim someone as a dependent, I don't know. But the student is still taking on significant debt in order to pay their own way. And so typically people who are in New Hampshire to be in school are financing that. And so whether they're doing that with the assistance of their parents or no, I think that's part of it. Number two, most of us are existing in New Hampshire at the sustenance of somebody, whether it's our parents or our employers. And I think that there's a slippery slope between saying, your parents are paying for you to be here, and so you don't have the same full rights of citizenship because your parents live out of state. Instead of, maybe you're remotely working for a company that's headquartered outside of the state and they're paying for you. There's obviously differences, but I think that that's a road that we don't want to travel down, is looking at the financial wherewithal of New Hampshire voters, because some people who vote in New Hampshire have no means to speak of, and so I'm, and given the history of voting in this country, I'm in particular look askance at the idea of trying to inquire into the financial respects of people. But I'll note that in general, the New Hampshire domicile definition has never inquired as to where your assets come from. It's really about, do you have a physical presence in the state, and is it your home for participation in democratic self-government? And how you get there or not, where your money comes from, has never before been a test for the domicile requirement. And so this would be something new. I understand that it is.
Just if I may interject, that one of the proofs of evidence of domicility, or if that's the right word, of domicile, it can be a tax form that has a New Hampshire address. So there is that connection. I didn't want you to forget that, but so it's not completely unique or out of it. It's not like it hasn't intruded into the election law discussion before, but it's an excellent point that you're making.
I mean, a tax form is a government document with your address on it. And so I think I look at that as proof of physical presence, more than as participation in democratic self-government in the state, because you may be paying, New Hampshire income taxes if you work in the state but live in Massachusetts, for example. If we still had income taxes, that may be the case. You would be paying New Hampshire property taxes if you own a second home in the state, regardless of whether it's your primary domicile. So I've always thought of that more as proof of the physical presence. But I take your point. And so I think that's probably the best job that I can do answering your question. And then, of course, there's the issue of what if a parent claims someone as a dependent on their tax returns, either mistakenly or fraudulently? thinking that they're providing half of the person's assets, but in fact they're not. I'm not sure that that the statute as written really contemplates that. I mean, it says legal dependent, sure, but I'm not sure that it does. And then you have that if there were ever an enforcement action, you're going to have to prove up everyone's assets and bring in forensic accountants to do that. And I'm not sure that's plausible.
It does seem to be following it to that extreme does seem to be beyond the pale. But I again, you're laying out a whole sequence of events there at that point.
That's my
So,
job.
All right, so I don't have any other questions at this time. I want to thank you
Thank
very
you.
much for your testimony, and we were able to get you out
Yes.
of here before your court appearance.
Yes, thank you so much. And I'll just reiterate that if anyone on the subcommittee has any questions about anything, I'm always available.
Thank you. I'll let the other remaining subcommittee members know that.
And that goes for committee staff as well.
Oh, thank you. Appreciate that.
Yeah.
All right.
Thank
Thank
you.
you so much. Good luck. All right. At this time, I'd like to welcome Mr. Daniel Richard to, I'm sorry, did you? Yes, Mr. O'Brien.
Thank you very much, Mr. Chair. For the record, my name is Michael O'Brien, lobbyist with Party Strategies and representing America Votes. I just want to bring up the second part, which is the attachment of UNH residency and state tuition standards to, and just read their definition for you, just so we're all clear. A student's resident for tuition purposes is considered to be that of their parent unless the student is emancipated. To qualify for in-state tuition status, a student or her parents, if a dependent, must physically reside in New Hampshire for no less than 12 continuous months prior to the term for which the in-state status is desired, must reside in New Hampshire for some purpose other than attending the university, and meet all the requirements for tuition rules. I also want to stress that in the beginning, it talks about how they apply this standard as a freshman. So you can't, this doesn't get revisited. You can't retroactively try to.
If they change it, so what you're saying is if the student were to change that from their sophomore to junior year, they're still obligated.
As I read it, the website says residency is determined at the time of admission for a degree. So not to regurgitate everything that Attorney Clementois just said, but this again goes back to dependency, right? As was stated in that definition, that it depends on where your dependents live, not necessarily where you live. And also, again, you could very well establish yourself in New Hampshire over the 4 years, but because this is set at the first year, you would never qualify under, and obviously there are lots of constitutional problems if I lived in a place for 4 years and was told that I couldn't vote. But more than that, all of the definitions made up here, 12 months to qualify and all these other things are longer establishment periods than contained within voting rights law. So just wanted to share that with the committee, make sure we understood what the definition was.
Yes, thank you. That's very helpful.
Yep, of course.
Appreciate
Thank you.
that. All right. All right, Mr. Richard, are you ready?
I'm as ready as I'm going to be today. How are you?
All right. Very well. Thank you for appearing today. We had just for awareness that Mr. Richard has spoken previously to the full election law committee, and after hearing your testimony there, multiple members, it was a bipartisan interest, were interested in hearing you come today and speak on various aspects that this subcommittee is looking at. So with that in mind,
I need my glasses.
That's what,
There's power out in multiple places because of the wind.
yeah.
Maybe the delay.
All right,
So
so,
glad it didn't affect me other than printing.
yeah.
So is this a quorum?
It
Yeah.
doesn't, you missed that part. It doesn't have to be a quorum until, unless we make an official action on a specific bill. So, let me give you the option, is it sounds like, if you have the time,
I'm completely flexible. I'm here to
All
be
right.
till close.
we could take a brief recess for a few minutes and allow more members to get here.
Perfect.
Let me, if you'll indulge me a moment, let me check if the other members will be coming here as well. I just got a message from one person that they would be leaving in 5 minutes, and that's they would be leaving approximately now. So let me just check into that. But what I would suggest, they're reportedly about 10 minutes away. So I would suggest maybe taking a brief recess until 10 of, and then that would allow us to do some things. Again, one of my favorite sayings is, "Blessed are the flexible; they will not be broken." So we will adhere to that motto, and we will be flexible, and we'll recess until 10 minutes before 2, and they'll reconvene and begin to hear Mr. Richard's testimony, and they'll allow me also an opportunity to speak with Mr. Allen. So thank you very much. We'll be back in a few minutes. for your indulgence with, we had a county delegate, there are some members of the subcommittee who had a county delegation obligation and therefore could not attend until just now. I want to thank Mr. Richards for your patience with our subcommittee. And we will at this time begin. And I want to welcome you and thank you for appearing. Again, I will note that several members of the subcommittee had heard Mr. Richards speak during the full election law committee proceedings during a public hearing and had expressed interest to me about hearing Mr. Richard speak further on some of his topics. And accordingly, based on those requests, I've invited Mr. Richard to come and speak before the subcommittee. If I could just also, if I could just request that people in the room not talk during testimony, please. Mr. Richard, I invite you to go ahead and speak. We may have one more member who arrive and he may have to traipse behind you, but we ask for your indulgence with that as well.
Blue is microphone or red is hot? Awesome. Thank you so much. Wrote it all down in case that way he'll be able to catch up to speed. Again, let's start over. Good afternoon, ladies and gentlemen, chairman, honorable members of the committee. Thank you for the opportunity to testify here before you today. My name is Daniel Richard. I'm a citizen of New Hampshire. I'm an inhabitant of Auburn. And those words, citizen of the state and inhabitant, will become very important as we continue on. And I'm grateful for this invitation and opportunity to share with you my 10 plus years of study and knowledge of these very important election law issues now before this subcommittee and the election law committee as a whole. I want to share with the committee my personal story as an example of some of the relevant election issues we're here to talk about today. The election issues before us today should remain nonpartisan as they affect all of us. Full disclosure, I'm a registered Republican and I vote Republican. Unfortunately, all the named defendants in my case are Republicans because they failed to obey their oath by refusing to follow the Constitution. This does not make me very popular with the Republican Party of the past. The sad reality is everyone in government, this is important, everyone in government today did not create the problems we're here to discuss, but rather we inherited these election changes by design when all the previous election laws were codified 46 years ago in 1979 under the previous Secretary of State, Bill Gardner. The act codified 195 years of New Hampshire election law by a single act and is now our current election statutes. That's how they all came to be, along with other changes since. That's a huge load that they took upon themselves. Think about it, to consolidate 195 years all in one act. And so that was 436:1 was the act. And I have copies as part of the records I've given everyone. And so it's impossible for anyone to be perfect. So the fact that there are issues that were properly sorted out when the recodification happened is not a huge problem in this respect. One of the geniuses of our state constitution is the ability to alter the document. And they found that out very early in our history in 1776, where that was what was wrong with our January 1776 constitution. There was no way to amend the document. But they would go on to draft the one that we have today after 3 constitutional conventions. And so the one we work with today of 1784 has been amended ever since. And in my case, for those of you who don't know, I currently have a case that went all the way to the Supreme Court on election law. It's been remanded to the trial court. I'll expound on that in a lot of specificity because it deals specifically with the affidavit questions that I raised when I testified last time, and I'd look to clarify them today. The issue is, as I said, The problem isn't that that the people that I filed suit against they didn't physically cause the problems. It's the cover-up. It's the refusal to address the issue. I did, in fact, use the constitutional right to redress our grievances by remonstrance, by giving everyone involved notice, from the Secretary of State to the governor to the Attorney General to my local municipality. Everyone had notice, and they chose, rather than address any of the issues, I had no choice but to go down through the legal process. So that's been entertaining, to say the least. Needless to say, today I'm very pleased to finally have an opportunity before this committee to address these issues. So thank you again. My background: I was born outside of the United States, 200 miles from here in Canada. My parents applied for and were granted visas, thereby establishing their legal status as lawful resident alien, which allowed my parents to reside permanently in New Hampshire as a permanent resident legal alien, a green card holder. This will become important as we try to deal with these issues of defining who a qualified voter is. And I think my personal experience will expound upon that. I was naturalized in 1981 at the Hillsborough County Superior Court in Manchester under state and federal immigration laws, which run parallel to each other under state and federal jurisdiction. My naturalization certificate defines me as a citizen of the United States of America, which also establishes my legal status as a citizen of the state of New Hampshire as defined by Section 1 of the 14th Amendment of the U.S. Constitution. Professionally, I've been a professional police dog trainer. I'm the former canine manager for the United States Department of Energy. I had 10 bomb dogs under my command. And it was that background that I first cut my teeth on learning law. I didn't go to law school, but because of the training agencies, I had to learn all their rules, their regulations, local ordinances and statutes, whether it be local, county, state, or federal agencies. So that's where the beginning of my interest began, from a different angle. I've always had an interest in American history as a hobby. I've spent the last 10 years of my constitutional studies focused on the New Hampshire state history of our state constitution and the form of government created by it. I've read all of the New Hampshire election laws going back to 1775, and most importantly, how the state and federal constitution and the statutes written pursuant thereof work together on the issues of voting and immigration, both relevant to our election laws. Several years ago, I was in Bill Gardner's office, and former Secretary of State paid me a very, very high compliment in a meeting in his office with several members of the legislature when he told the representatives in attendance that he believed that I knew more about our Constitution and our election laws than the lawyers and judges in the state, and I was profoundly taken back by that. And it led to his invitation to teach a constitutional law class to his entire legal staff, including Bud Fitch. Many members of the House of Representatives were in attendance. I filmed the whole thing. I'd be glad to do it again if anyone has the interest. But what I did is I walked everyone through knowing the beginning. What a real important part of understanding how to fix legislation that is being looked at for revision is to understand where we came from. This is the tool the courts use, right? The state Supreme Court uses the same instrument, which is judicial scrutiny, is always based on what did the founding fathers say and do at the time. And recently, the U.S. Supreme Court has reaffirmed that, and we'll talk about that later on, as to how those recent precedents are now going to change the way we look at dealing with legislation. I've argued 2 cases before the New Hampshire Supreme Court. The first case being the right to petition or remonstrate before the legislature for redress of grievances, which I alluded to earlier. And the second case, of course, has been remanded back to the trial court after establishing standing before the state Supreme Court. I've listed the video link from the state website if you care to see it. Those are the links that would take you there from 2021 and 2023. Proposed election legislation now before the Election Law Committee. I'm here to share with you the importance of the historical and legal definitions of both voting rights and naturalization laws of the state of New Hampshire. The following is the foundation or standard of review that I will use to render my opinions about any election or naturalization questions you may pose to me. Any of my opinions of the proposed legislation will be mindful of an important fact that all legislation must be written pursuant, excuse me, I lost my way. My opinions will be based on proposed fixes to legislation must be written, and they must survive judicial scrutiny. Anyone who's been involved in litigation, I know sometimes when I hear the attorneys come testify about proposed legislation, they'll always give that cautionary note that in the end, you're likely to have some type of legal challenge. So it's important to go ahead and make sure that you're mindful of these things. And that's what I want to cover with you today. What are those constitutional or statutory issues that are going to hinder a possibly good idea that has conflicting statutes? And that's where I thought I'd be of great help to the committee here today. So the big part of this too is that, and we're going to get into this, is Article 90, and that is that Article 90, which is that all proposed changes to our statutes must be done so in harmony with our state and federal constitution. Whether the election laws in the past or the immigration laws were changed by mistake or design should not affect this committee's ability to recommend solutions to the legislature, which is still constitutionally authorized to fix these issues. Part 1, Article 29, leaves to the legislature the responsibility to suspend the laws or to make the laws and no other. And so that's really important. So you are constitutionally authorized to make these fixes. The next part. Because whatever the legislative solution is, it must still be in harmony with Part 2, Article 90 of the Constitution of New Hampshire, which requires that the common law, which was in effect prior to the adaptation of any new proposed legislation, must be in harmony. The backstory to Article 90 is that when New Hampshire was settled after the Mayflower Compact and the first settlers landed here, we had nearly 150 years of occupancy till the Revolution. And so when they wrote the new Constitution that we're working with today, they had to figure out, gee, which of the old law, of the old English common law that's practiced here in America, what are we going to keep and what are we going to push away? And of course, all the things that they didn't like that came from the king, they were going to dismiss it. So Article 90 says very clearly, all laws which have heretofore been adopted, used, and approved in the province, colony, or state of New Hampshire, and usually practice in the courts of law, and this is the key, shall remain and be in full force. So when you're dealing with this, in my opinion, when you're dealing with a statute that has, that is going to radically change the past, you need to make sure that it isn't going to cause conflict with the other consisting or the other provisions of the Constitution and or relevant statutes. And then it goes on to say that, again, the legislature can, in fact, make those changes until altered or repealed by the legislature. And then the caveat, such parts thereof only accepted as are repugnant to the rights and liberties contained in this Constitution. So new legislation that fixes or attempts to fix the past must still be in harmony with the Constitution. And this is where a lot of these things I've discovered about the 1979 recodification of our election laws, as I said, is there are some mistakes there. Whether, it doesn't matter why they're simply there. And a lot of this has to do with the fact that our civics curriculum is quite lacking in the state now. We're no longer teaching the state constitution in our civics curriculum. There's no longer that mandate, only that students only have to take a federal naturalization examination as part of their passing their school curriculum. And I think that affects the lawmaking process sometimes in a negative way, because when, as some people have publicly stated, some reps have publicly stated that it's not my job to know whether the proposed legislation is constitutional. It's for the courts to figure out. I would vehemently disagree with that. I believe the current House rules govern that every vice chair of every committee is supposed to know or make sure that any proposed legislation in his committee can only move forward if, in fact, it's constitutional.
Yeah, yes, thank you, Mr. Richard. I want to confirm that is actually correct. That is the rule that we have, and You're absolutely correct. Every vice chairman of every standing committee is supposed to do that as part of their rules. So thank you. I also gave you a chance to get a drink of water there.
No, thank you.
So-
Thank you. Reading the room. So anyway, that's Article 90. Now, Article 90 goes on to say that it, when compared to the 23rd article in the Bill of Rights, shall be construed to affect the laws already made respecting persons and estates. In other words, you can't pass retrospective laws. That's a big deal. So that 90 and 23 work together. And by the way, most of the Constitution, there's a lot of synergy and harmony in the document. Part 1 was created on purpose. The Bill of Rights is first for a reason. There is 38 in the original text, more now with additional amendments and changes, but 38 in the original. And Part 2, the form of government, in my opinion, was written, and the courts have reaffirmed this, was written specifically to protect Part 1. That's why it exists. So unlike the U.S. Bill of Rights, which is backwards, the U.S. Constitution was written, and then the states, half of the states that considered the adaptation of the U.S. Constitution wrote what we ultimately know today is the Bill of Rights. New Hampshire specifically had 12. It had 12 provisions that said, hey, if we're going to adopt this new document, we want to go ahead and follow that course. But anyway, moving on from there, affidavit issue. Let's get to the affidavit issue. I want to begin by pointing out some misleading testimony a few weeks ago. And I've known Secretary Scanlon for a long time, and I was disappointed to hear these things, but they need to be addressed. And a few weeks ago, as you well know, we were here discussing House Bill through the full committee on House Bill FN 608, or I'm sorry, backwards, HB 608 FN. And that bill is being proposed to address a conflict with the interpretation of the word affidavit. Representative Lane asked a brilliant question. I wanted to leap up and hug her and get her some roses because she asked the $1 million question, right? I've been trying to get the state government to answer that question. What do you consider a properly executed affidavit? And the sad reality is that the Secretary of State withheld some vital information. And that vital information is part of this package, and I'll get to it. The election procedure manual is different than law. It says on page 4 that this is not law. And on page 154, this is what he left out in his testimony. Determining if a voter properly executed, by the way, there's an existing statute that was on the books when all of this happened last fall. House Bill 1569 that the chair of the big committee passed a law that says no exemptions on voter ID. The problem when they did that is that they actually passed a retrospective law. They repealed 65930, which is the statutory definition of an affidavit. And so it says clearly there that in the 12 provisions that the legislature has established for an affidavit to be executed, it says that they must all be done in the traditional norm, right? The word is 500 years old. The courts have been using it and still use it. You can't have an admission. If you're going to change it, that'd be one thing, but they didn't. Upon finding the defect, as Secretary Scanlon gets to in his testimony, they didn't fix or suggest that we fix the problem. They fixed it in the manual. And here it is. Determining if a voter properly executed the affidavit envelope. An affidavit is properly executed if A, the voter has completed the affidavit and signed it with a legible signature. The absentee ballot affidavit envelope was amended by House Bill 555 and now does not require the voter to mark the specific circumstances that permits the use of an absentee ballot. The voter signs the affidavit which states one of the following applies with me. That's A. Now, before we go any further, if the legislature chooses to reduce and change an affidavit to an unsworn declaration, right? You at least need to tell the moderator why it is you're claiming to vote absentee. Representative Lane is moving a CACR to kind of go to eliminate this issue from a different perspective. But the way the law reads today, how can you even claim that that's in fact permissible, right? To say, well, gee, and that's part of my lawsuit, which says, look, you can't put 7 excuses on the envelope and say, and not declare which of them applies to me. Never mind, there's no eyewitness and there's no notarization, no chain of custody on this. And this is the big problem. B, the affidavit is signed with an illegible signature. You must assume it's the voter's name. Think about that. No, that's not a sworn affidavit. B, so C, again, you have to assume that the person's disabled if you can't read their signature. And C, the one that's really bad, there's no voter signature on the affidavit envelope, but there is a name and a signature of the person assisting the voter. You must assume the voter has a disability. It prevents the voter from signing his or her name. In other words, the absentee ballots that are submitted to your moderators for disabled people, we don't even know who they are because their name isn't even on the envelope. There's no provision for any, there's no space on that envelope. I have a copy amongst this, all of this to figure that out. It's not even there. So this is a huge problem.
Thank you, Mr. Richard. Let me just ask a question just a moment, just to confirm we know exactly where you're reading from. That is the
24. It's the current
2024.
version with the pretty purple cover to it.
And that's the election law manual, and you're reading from
Page 154, duties of the moderators.
duties of the moderators. And so that, and it's your premise or assertion, I don't mean to imply any thing in there, but that the Secretary of State's office, through the election law manual, attempted to oh wait, no, that would not have been 1569 would not have been in place
No,
until
you're
November.
correct.
So that is, so the election law manual is not reflective of 1569.
Well, my issue with the election procedure manual is simple. The legislature makes the law. They don't. That's what I left. That's what I teed off for the secretary in his testimony was I said, look, the legislature makes the law. Secretary of State can't make law, and neither can the Attorney General's office. And the state of Arizona has just held their Secretary of State in contempt of court for the same issue. The difference between Arizona's election procedure manual and the New Hampshire, the only difference there is that they permit by statute that Arizona law, that the manual is enforced as law because it's written by the legislature and not modified by the Secretary of State. And that's where the Arizona Secretary of State got himself in trouble. And it's the same thing going on here, is that seeing a defect or a difference of opinion, they've chosen to write a solution as if they have lawmaking power, and they don't. Now, if the legislature wants to do this, that's for the legislature to decide, but not for the Secretary of State because he has no lawmaking power. He's the secretary. And he reaffirmed this in his testimony over the printing of the election manual, the printing of the text on the envelope, on the absentee affidavit envelope. He said, I'm powerless. I follow the law. Right? That was his testimony, and he's testified the same. And he's correct when he says that. He doesn't have any discretionary authority to make law. Neither does the Attorney General. And I think there's a serious defect in separation of powers over this issue of letting those two do this. Because again, it's up to the legislature to do these things. And that's really my disagreement with it, is not so much the substance of this, but.
So again, just sorry for the interruption.
No,
Just
it's
a
good.
quick question is the recent ruling on Bruin and its impact on administrative rules, is that
Wrong case, but I get where you're
Okay,
going with that.
Okay,
I know where you're
what is the
going.
right case then?
So the right case you'd be talking about would be the Moore v. Harper decision.
Yeah, okay,
And
right.
also the decision last summer, which is the NAACP of South Carolina versus the South Carolina legislature. And where there is where I found a lot of case precedent to support my position over federal issues was all these redistricting fights. When they end up in front of the Supreme Court, they always say the same thing. We don't have the authority. We can't tell the state government how to redistrict. That's for the state legislature and or the federal Congress. If you look at the second part of Article 1, Section 4 of the U.S. Constitution, Clause 2, that is a fascinating story I'll tell you about on that in a second. But that provision says that if the state legislature refuses to establish the time, place, and manner for conducting the elections, that the federal Congress can. And the Moore v. Harper decision, it went further and it said, we as the Supreme Court are not delegated any power under Article 3 to do this. So it belongs with the state legislature. And again, if they're going to fix the problem because the states refuse, and that's, matter of fact, you find that in Article 4 of New Hampshire's consent to the U.S. Constitution. The fourth provision in that document was that we agree to the new Constitution under these conditions, and one of them was that the federal legislature never exercise the state legislature's powers unless the state refused to establish the time, place, and manner. And I found it fascinating that New Hampshire put that there as one of their conditions, but that's a big piece of it.
All right. Thank you. I didn't mean to take you too far down a side road there, but I appreciate the testimony about that. That is, of course, of interest to us as well from an election law perspective. But let's return to the affidavit issue that you were discussing, and if you would continue with your testimony, that would be much appreciated. Thank you.
You're welcome. Yeah, I was looking back on page 4. I went too far. Okay, there we go. Also, another decision, I stopped where I was talking about Article 90, and I wanted to reaffirm that from the state Supreme Court. In a long time ago, in a famous case that still stands today, Merrill versus Sherburne. Merrill versus Sherburne reaffirmed the repugnant or contrary provisions in the Constitution in 3 places, and it's when it said the following, quote, "That clause which confers upon the general court the authority to make laws provides at the same time that they must not be repugnant or contrary to the Constitution." And that's exactly what Moore v. Harper did, which was another redistricting case. That case had to do with the North Carolina legislature, spearheaded by a Republican majority, abused their power. They abused their power and they said, hey, since we get our power to redistrict federally from the federal elections clause, no one can tell us what to do. And that's what took them all the way to the Supreme Court. And the Supreme Court said, sit down, little boys and girls. Yes, we are going to tell you what to do. And so that's where and all of those cases, by the way, that are part of some of these additional filings I have for you to read at your leisure, all address the same thing. They're all about that the state lawmaking power must always follow the state constitution, and it can't delegate its authority. I'm not going to get into the Ballot Law Commission, but some of this case deals with that also, of delegating lawmaking power to that body as well. To continue here with this, what I wanted, and I just alluded to this about his testimony, is that he affirms, and the secretary affirmed some of my arguments in part. Some of it was misleading in part, and some of it was flatly not very honest. And I wanted to make sure that this committee understood this, and I voiced these concerns to Chairman Berry as well. There are 8 relevant issues to this election law case regarding Secretary Scanlon's public testimony on the affidavit question. A, Secretary Scanlon's testimony addressed the proposed legislative amendment to fix 65951B. And that's what House Bill 608 is trying to fix, is to clarify the discrepancy between the statutory definition of an affidavit, the execution of an affidavit, and the election procedure manual, because we've been operating under the procedure manual and not following the law.
If I may, just to clarify, you may continue your testimony, but just I was notified that there was in fact an error in the public announcement of the working session regarding the possibility of working on HB 608. That was already execed by the full committee, and therefore that will not be handled any further by the subcommittee. But if you're having testimony relevant to the theme as a whole and it involves your considerations of 608, I think we can still hear that without any problem. Just the committee
Yeah.
will not be working on that. So just that was announced at the beginning, but not everyone was here at that time. So I just want to make that announcement again and clarify. So thank you.
Yeah, no, I bring that issue up only because the Secretary and the AG's defense on this issue has been to ignore the moderator's duty and focus exclusively on the voter's responsibility, how to properly vote, the voting process, and the beginning of the chain of custody. So he's now telling us that he's aware of the issue, because in the court, what he's doing is he's there. One, I'm sure that the AG isn't thrilled for him to have testified, and now they're actually saying something about an issue that if their counsel had better oversight, they would have said, don't say anything, but they did. So now there's a conflict between him and the Secretary of State on this issue. And that is that, again, they're using the election procedure manual. They're not following the state law. B, on the second part of his testimony, was just what I alluded to. 657.7 does not contain the language directing the SOS to print the notary certificate on the return envelope. And that's what his testimony then. And what I brought with me today are the historical journey from 1942 up till current, and we'll cover that when we get there.
Just to not to spoil your punchline, but just in two summaries, had it been there before, and it has been since removed? Is
Yes,
that what you're
exactly.
saying?
That's exactly right. So the process was in effect from 1942, and I have a copy of that amendment, from 1942 to 1979, and that's exactly right. It was there before, and they kept the word the same. So the envelope that had a notary certificate and that process was in place was called an affidavit envelope, and the name stayed the same, even though the duties of both the moderator the moderator's duty stayed the same, but the voter's duty changed. So the voter is no longer statutorily bound to appear before anyone. And so that's been their legal defense, is that, well, I only print the envelope the way it's instructed to. And that says that under the current statutory scheme, that the voter doesn't have to do these things. And that's going to be part of this committee's decision on what to do about affidavits. The next piece on this, Secretary Scanlon also reaffirmed my testimony on all this historical thing. He broke it down very well, and I have a copy. Part of my testimony that I've got here is the transcript of that. I did my own transcript as best I could. He also reaffirmed that the state election laws were in fact recodified in 1979, and the aforesaid changes included most of the election statutes now in question here today. E, that the SOS, has directions on the language that shall appear on the envelope. This is true. It's exactly correct. He follows the statute as it's written. Now there's a conflict of interest between the Secretary of State and the AG's office. Secretary of State and the AG's office, because now he's giving, rather than remaining silent, they're now giving testimony on this issue. And so that's not going to work out so well for them. But anyway, And then, of course, Representative Lane asked the brilliant question, what do you consider then to be a proper affidavit? And he told us from his perspective. Secretary Scanlon's testimony is also relevant because of the conflicting testimony between the two. And so next in line, if you follow through on the bottom of page 6, is actually his testimony. I would like to run through it briefly, if that's okay.
If I could ask you just to maybe touch upon some highlights, I think, again, I would reiterate that some of your comments early on that
Covered all of
was
this.
an inherited aspect that the secretary has had to deal with. And so,
It's all in print here, so I'll skip over and get to the money. The money on this is the very end. Responding to Representative Lane's question, he said the following. Well, I think the case, in this case, the affidavit is what the legislature calls it. But sure, there is a legal definition of what an affidavit constitutes, and I think Mr. Richard is well schooled in that. But I think the legislature can say something and mean something else. This is a big, big problem. Are you telling me that if the legislature writes a statute that you don't necessarily agree with it, that you have somehow a discretionary authority to use the election procedure manual to fix the problem? That's what's happened here. And that's where we're going to need a fix.
I will make a charitable note, is that sometimes the legislature may in fact write contradictory laws themselves because we are gifted in our ability to do that. Present company accepted, of course. And so I will give the benefit of doubt to all parties involved as much as I can. So thank you for the clarification. I appreciate that. Please continue. I know you have 17 pages of testimony, so I don't want you to miss any
You
salient.
said put it all down.
I did ask that in my email, and at the bequest of my bipartisan requesters of your presence here. So I acknowledge my failings in saying something like keep it to 8 pages, but having since you have done so well to put this all, I guarantee you, we are all readers here on this subcommittee. This will not go unread.
Awesome.
I want you to know that. So, but may I suggest that you continue to go through, and there's a lot here. Do you think you could be finished?
Yeah,
by
I can
3
speak.
or 3:15?
I think I'd be done by 3:15.
Okay. Yes. Oh, please. Anytime. Yes.
Thank you. And so can the legislature decide what an affidavit is?
If
Or-
it chose to do so, I believe it could, because it is the ultimate law. All that power is delegated to that body for that purpose. And so I think that's what Secretary Scanlon was saying, is that the legislature defines the word. And what you find throughout, if we use all of the other places in where affidavits are required, and I did this study, there's 262 places in state law where, in specific places where there is a specific process required because of the purpose of the affidavit, you'll find that either the federal Congress or the state legislature will define the parameters for that application. And in this case, if it was going to do so, that would be a fix. The only caveat being, as long as it's not contrary or repugnant to any other provision.
So it doesn't necessarily have to be consistent, does it, with the other chapters of the law? This is my question to you. Or can we define it for purposes of the election law, like the 650s, all those?
It did
State-
659:30
Right.
before it was repealed.
Right.
And it was there before the recodification. And let me make a really important distinction about affidavits. And a lot of people that I heard testimony to when I testified last time were concerned about the burden it may place on the voter. And they were skipping the all-important point that I'm going to touch upon now with the Supreme Court case, in my Supreme Court case, and that is it's not just about the affidavit. It's about the chain of custody and the beginning of the chain of custody. In other words, if we're going to apply election laws equally to everybody, then the practice that was in place for in-person voting should apply equally to absentee voting. And that's what they did in 1942. That's what was in effect till 1979. And these changes, either by design or mistake, came to be. And this is why we have this disparity. And so the key is that was removed in 79 was the following. A voter, upon receiving his absentee ballot package, has a responsibility under the old provisions to show up in front of an election law official. That would be one of 5 people: a notary, a justice of the peace, a selectman, a clerk, or a moderator. All 5 of them under the 65930 were authorized to act in that capacity. And what was required was, one, they would verify that the ballot wasn't pre-marked. Whoever is helping you vote absentee confirms your ballot isn't pre-marked. Then the next thing they would do is you'd mark it in the vicinity, just like we do in person, and then you'd go and deposit your ballot into an envelope instead of a box or a machine. And there was an eyewitness, just like it is in person. So the notary certificate was just the sealing the deal, right? Confirming that the process, we now have a lawful chain of custody and everyone's being treated the same. So that's the real underlying issue. It's not just about having it notarized. It's about starting a lawful chain of custody. And of course, now 659 adds an additional complication. How are we going to now not address this issue? Because now we're going to run into the Equal Protection Clause. And let me share with you the state Supreme Court's decision. In my case, I only cherry picked the relevant point. Line 20, quoting the court, the plaintiff alleges in his complaint that the defendant's sanctioning of discretionary use of voting machines at the local level violates the Equal Protection Clause of Part 1, Article 1 of the state constitution and the 14th Amendment to the U.S. Constitution by authorizing use of programmable open source electronic voting machines in some towns and cities or other political subdivisions of the state or not. This is a big problem, right? When the statutes were passed in 1979, they were done for a trial basis, for a temporary trial basis. And I think this is what was going on then, that they didn't realize they were inheriting a secondary problem, which is this problem now. So in order to treat everyone the same, are we going to force the 103 towns in the state an unfunded mandate to say, hey, you now have to get machines like everybody else? Or are we going to force the 135 towns to say you can't use machines until the legislature figures this problem out? That's what they did in Massachusetts, by the way, because these provisions, John Adams wrote the Massachusetts Constitution. We used it as a template. And so that voting provision was the same. And so Massachusetts, to address the voting machine issue, did in fact put it on a CACR, and they got it approved. And so it's uniform throughout the state of Massachusetts. Whether you like it, dislike it or not, that's now a provision in their constitution. And it's not here. This is one of the other underlying issues, is that we have all 103 towns that choose not to. We have 135 to do. Now, this really gets compounded in a bad way when we go to the next step with the affidavit problem. I argued on appeal, very importantly, that if the moderator does not authenticate that the affidavit was properly executed under that provision, 65950B, which is the affidavit appears to be properly executed, and he goes ahead and removes it out of the envelope instead of disposing it as required by state statute 65953. Material defective. That's the requirement on that as far as dealing with an envelope that is not properly executed. And so if you go down that process, that, I'm sorry, I lost my way. Where was I?
So you were talking about the affidavits in the context of the absentee ballots.
Correct.
And so, and pointing out there's a section of the RSA's beginning at 659:46 and continuing on for several pages up through 659:55 that concern the processing of absentee ballots. And so I think
I was at
you
the
were-
Supreme Court. I found my way.
Okay, great.
So
Thank
the-
you. I stalled as long as I could. So
That's okay. So the four items, the disparity in the towns using machines versus not, and then the counting of unverified ballots, they found problematic. And the second issue is that as soon as you remove a ballot from an absentee envelope that doesn't have a properly executed affidavit, you put it in a machine, it can't be reconciled. HAVA required that all the states adopt a proper manner in which we can do proper recounts. And there's another reason that that ballot can't be recounted. It's not a lawful affidavit. It's not admissible in a court of law. So we have a secondary problem. So you're puzzled, but go ahead, ask.
So, could you repeat your statement regarding how this violates HAVA?
Yes, if there's no way to do a lawful recount, because even though absentee ballots are in some cases of a different color, they're named on the face as an absentee ballot. The problem is that if they've been removed from the affidavit instrument and put in the machine, now there's no way to reconcile who is who, because we don't know if, let's say you have 1,000 absentee ballots and you don't know which one. Some people, by the way, who do return their absentee ballots, let's say you're scheduled on a trip, you apply for an absentee ballot, and then you find out that your trip is canceled. Some people will simply take that absentee ballot, go to the town. They're happy to check you in, right? So some of those will actually have a notary authentication. It goes back to the town at the local level for counting. So 103 to 135 is 1, unverified ballots is 2, 3 is the inability to recount them properly, and 4, certifying the election with unverified ballots.
May I ask you a practical question about this aspect of recounts and the absentee ballots? Would, in order to maintain you're worried about the chain of custody when there is not an official not a legal affidavit. So if someone had a legal affidavit and removed it from the
envelope.
and then processed it, would that be acceptable under those conditions or not?
Well, it would be. The problem is you have all the others that aren't. That's where you get into trouble, right? Is that it's not the person who actually has a lawfully executed affidavit. It's diluting that vote when you then add all of the others that have not been checked.
Right.
And by the way, in 2020, just so you know, we maintained an average of 4% of the 3 previous election cycles prior to 2020. 4% is our average, okay? 2020, with the expanded absentee provisions that were brought about because of COVID in other expansions, but statutorily, we went to 32%, over 260,000 absentee ballots. And one of the things the Supreme Court found, and I'll finish up their quote, according to the plaintiff, this disparity between methods of counting votes and the non-verifiability of ballots submitted by electronic voting machine at the time of counting and later for auditing, parentheses, recounts, of the validity of each ballot and vote produce an unreliable outcome and a hidden opportunity to manipulate the computer counted data. See, I didn't argue that the machines were being flipped, that they were being accessed electronically. I simply argued there's a process, and the process isn't being followed because that is the only statutory enforcement I have under election purity. 666:2 and 666:3 are the statutory provisions where if local election officials or anyone involved with the election process doesn't follow the process, that is my only statutory relief available to me. So claiming fraud, and my argument in my brief was every single absentee ballot they're all defective.
when you say defective, just to make sure I understand, is because it did not have a proper, a legal affidavit that established, as you discussed, the lawful chain of custody. If that's correct, right?
You're right.
All right, and then just to follow up on that, so if, let me take one extreme and say, if every absentee ballot had come in with a legal affidavit, as we've defined, at least in our discussions here, at that point, that would have been acceptable because there was, at that point, a lawful chain of custody would have been established. I'm trying to think about legislative solutions, not just your case
Sure.
specifically, and that's the point of my question. So if it had had the full legal affidavit, at least that aspect of your case would have not been germane, because every absentee ballot at that point would have had a legal chain of custody.
Right. And that's what the affidavit is. It's verification of the beginning of the chain of custody. That's the key here. So it's not just the affidavit instrument by itself, but rather that someone witnessed you insert your ballot inside of an envelope, and that begins the process.
It is this, not, again, not to put words in your mouth, but I think because of the equal treatment of people's equal protection clause, we cannot treat someone who has an absentee ballot different from someone who is present on election day. And in the election day mechanism where people are present, they have people who are witnessing them handing out ballots, putting them and following and tracking them from taking that ballot from the point where they're obtaining a ballot, confirming their registration, obtaining a ballot, marking it as necessary, and then delivering it to the machine. That chain of custody is established by the witnesses at that election poll.
Correct. And the only difference between the absentee voter and the affidavit is the extra step. But the extra step is necessary to not be burdened with voting with everyone else on election day. Right? If you're going to be exempt from that process, because I did hear that in testimony from opposing the bill, explaining the burden that may befall certain people because of their health conditions or others, and so they brought that up as a great question. So yes, I think that's the answer.
So Representative C first, and then Representative Lane.
All right, thank you. I'm gathering that it's a two-part question here. I'm gathering that for the affidavit on an absentee ballot, it only needs to start the chain of command or the chain of custody at the time the person is going to mark the ballot and put it in the envelope.
Correct.
So wouldn't need it just to, call up the clerk's office and say, hey, send me a absentee ballot or anything like that.
Well, I don't see anything broken with the current application process. In other words, everyone, the key in Article 11 of the Bill of Rights establishes that you're already a qualified voter, which means you're already registered in your local community. So when you apply for your absentee ballot, if you're not already registered, they can't send out a package. They have to make sure that you are, in fact, registered in your local community. So that's an important distinction.
And then to follow on that, the various people who can be the legal witnesses, notaries, justice of peace, and whatever, what happens if you're out of the state or out of the country? Do we need to have, out of state, you can get a notary or justice of peace easily enough. Do we need to have them certify where they have their commission?
Well, my answer is always what was going on before. The beauty of our state is that we have been here so long in a continuous manner that my first problem-solving tool is to go back and what were they doing before we changed it, and was that a bad move? And so that would be my response to addressing that issue.
Okay, and then the only other part of that is if you're out of the country, would a
I know the military has deferred to their commanding officers as a surrogate, and so that's always been I believe, the way
Okay.
we deal with
Or
UCAVA
possibly-
voters.
Possibly an embassy personnel or something like that.
Correct. Correct.
Okay. Thank you.
I think there are other states that have that in their election laws that you can use an embassy or consular or something of that extent. So, Representative Lane.
Um, my concern, and I've heard what you were saying, but my concern goes back to, if we look at what was happening in 1979, what if we're not happy with what they were doing? Because there are a lot of people who can't, they're homebound or,
Right.
I mean, how do we, again, to echo the legislative mind, so how do we resolve that issue, but yet try to treat them the same?
Great question. And I think the answer is in Article 90. And that's why I started
Okay.
early on in explaining that is whatever changes the legislature proposes, and it's free to do so, right? It's unlimited in its capacity to offer solutions. It is not constrained by anything other than both constitutions. So if, like, for example, with the CACR that you proposed, right? I'm not for or against the bill. All I'm pointing out that I think I pointed out in my testimony was that provision runs into other problems that other provisions of the Constitution, they would have to be altered as well. And I think that's so if we're going to be a recodification, for example, right, that things need to change for whatever reason, that we're still bound by making those changes because Article 1 of the Bill of Rights says all government of right originates from the people. And the last sentence of Article 101 in Part 2 says that this document can't be changed without the consent of the people.
Right.
And so this is an important piece. So that would be my answer and I say this to people all the time. If you sometimes the proposed legislative changes are I'll pick on parental Bill of Rights for a moment, since I know it's a hot topic. My argument is it's not necessary. It's not necessary because the parents already possess that authority under the Bill of Rights. So the fact that you've surrendered your children to the state is another problem. That's the real problem. So don't complain how they handle it, but that's my take. That's an example.
Representative Burnham.
Yes, thank you. Do you think that absentee ballots should be held accountable just like official ballots? And I mean accountable from the moment that a clerk receives them from the Secretary of State's office. Official ballots are counted
Right.
by and witnessed of those countings. They are separated by testing samples. Or from the testing samples, and then they are placed and sealed until election day. Okay, so that process has happened with the official ballots. However, when they receive absentee ballots from the Secretary of State's office, it is not handled that way.
You're right. And when you look back at the past, you'll see that the absentee voting process is been monkeyed with for a long time. And I don't. Please rephrase the question for me.
Do you believe that the absentee ballots should receive the same chain of custody and accountability as our official ballots?
Article 11 says so, right? That the election process must be fair and equal throughout. So this is what's not happening now, is that we're not treating them the same. They're being treated differently because there's no verification of who they are. Like I said earlier, we've gone from the word affidavit to a process that closely resembles an unsworn declaration. So that's not what it is. I mean, if the legislature was going to make it that, then it'd run into other problems of not being able to verify. So the answer to your question is yes, I believe that they should be and they have to be dealt with the same way. They can't be treated differently.
I have a follow-up, please. So with that in mind, currently absentee ballots aren't counted. They're not being tracked. Some clerks say that they do track them personally just so that they are aware who they sent, how many times they may have sent one out to a voter. Because sometimes that happens. They
Right.
may not receive it on the other end, or they may have thrown it away, or maybe they went somewhere else and they needed it in a new location. None of those are necessarily being tracked, from my understanding. And then they're not being counted, reduced from the total of whatever total that is from the Secretary of State's office. They're not being counted at the clerk's office. The only absentee ballots that are being counted are the absentee ballots that are being used as an official ballot, if they've run out of the official ballots, or any absentee ballots received to be processed on election day. There is nothing in between if they've been spoiled, like our official ballots.
Right.
Our official ballots are spoiled. Those are calculated as well in the final count of their ballots. And at the end of the day, we don't know how many absentee ballots we have remaining, but we do for the official ballots. The process is not the same. And I'm just, my understanding is that there's no need to have to worry about that. It's the absentee ballots that are being processed through the machine or hand counted.
And that's really part of the problem, is that you'll find this fascinating. When they first made these provisions in recodification 1979, if you were using voting machines in your local voting district, you couldn't count the absentee ballots. You had to count them by hand. And you couldn't start counting them till the election was done. So at the end of the day was when they were done. So they were all put aside. And once the election day was over, then the moderator would make his announcement that he's going to start counting them. But yeah, they used to not, because remember, Part 2, Article 32 of the election provision for the moderator, selectman, and clerk says the moderator is to sort and count. The machines can't sort. They can't do an examination of the ballot. And that also, when we added this piece to it, to the election process, we also eliminated the problem of doing the fix before the certification. So the moderator could fix this problem in the moment. And so some of these changes, like I don't agree with the starting early in the day, only because if people want to challenge, most people are working 9 to 5, where whatever their time frame is. If you start doing it early in the day, you're unable to make these challenges. And now we're being legally threatened with consequences, but that's another story.
I do have one more, but
Let me just
trying
to
to stay on
clarify
task.
your questions and the response. So there's a distinction between an absentee ballot package and then which contains a set of envelopes.
Right. 2 envelopes.
2 envelopes, an affidavit envelope and a mailing envelope. And then there's also the blank ballot. And then you've been talking about before the ballot is marked. My earlier conversation with Mr. Richard discussed the ballot after it was marked and the chain of custody. So I just want to clarify, we're using the same terms, but we need to make sure we distinguish where in the life cycle that ballot is. So I just wanted to clarify that for anyone who might be listening or thinking about this. Did you say you had another question? We will entertain Representative Lane's. She's had enough. We'll get back to Representative Burnham in a second, but I have to give equal treatment here. As the chair, I'm trying to do a balanced, unbiased situation. So Representative Lane, please ask your question.
So, with my legislative hat on and trying to craft an affidavit, and you talked about self-affirming, so I'm kind of going, that's not really in your mind an affidavit.
No,
Correct.
no.
Okay.
Based on usage and custom and history, the word is 500 years old,
Right.
and the courts have established its definition, and so has the legislature in 262 places.
Okay. If we wanted to,
Yes.
if we wanted to say a self-affirming affidavit would suffice because they're signing to say it's subject to the penalties of perjury, that we lay out what the penalties are, that there's a civil penalty and a criminal penalty and all that, and they sign that. In your mind, it's not and I agree, it's not an affidavit.
Correct.
But would that be enforceable in court if they've signed it?
No, because there was no witness, right? There's no beginning of the chain of custody, because
Okay.
that's all the affidavit is for, is to reaffirm that we've begun with in other words, everyone who casts a ballot must cast a ballot in front of someone authorized by law to be an election official. And that's what we're dealing with here.
So have you thought about how we might try and solve this chain of custody issue for people who really are homebound or can't get into the clerk's office, and don't necessarily have the money to pay? I mean, it can cost anywhere from $50 to $100 to get someone to come to your home
Right.
and sign an affidavit.
Yeah, no, my answer to that would be to do what we used to do in the past. For example, people in nursing homes, right? Dispatch someone who is authorized to do so at the state or local people, in other words, at local expense, to make sure that they get to exercise their right to vote. That would be the solution, is to make it be part of the responsibility, because the state carries the burden to make sure that that the voter integrity is maintained.
So then it would be incumbent upon the clerks or whoever we decide to go out to these people. I mean, they're not all in nursing homes. A lot of them
Correct.
are, living in apartments or
Yep.
living in their homes. So do we then have it be the responsibility of the clerks to go out, say on designated date? I don't even know. I'm kind of.
Yeah, no, and be honest with you, it's beyond my pay grade to make that decision, because I'm not in the legislature, so I can't speculate to
I'll
how
sign
I would.
over my huge salary at $100 to
No, you're welcome. So I'll move along here, get on to, I think,
Mr. Richard,
Oh,
if
go ahead.
I'm now that we've allowed Representative Lane a turn, we're now back to Representative Burnham to follow up with her questions.
Thank you. I'm just really passionate about my absentee ballots.
There you go. I'm glad you are.
So I've kind of been on this for a little while, and I'm just want some clarity, and support would be great. So with that, we find that there are some people that cannot come into a polling place, but they
Right.
can be driven to, say, the door, and the moderator can come outside, or ballot, election official, with an absentee ballot. So that absentee ballot, which has not been counted,
Right.
comes outside, and it's being witnessed by that elected official of the voter completing that ballot. But it's still an absentee ballot. I've never gotten a firm answer as to why that needs to be an absentee ballot versus an official day ballot when the voter's coming to the location, but not inside.
Right, because now you have, what I can tell you from a practical perspective is the absentee ballot is labeled as such. All absentee ballots are printed absentee ballot at the header, and many of them are a different color. So you'd be looking at a legislative solution to convert an absentee ballot into a normal ballot. Now, there used to be, and there may still be, I don't know I'm not solid on this answer, but there used to be the ability to take that absentee ballot and do exactly that, to show up on election day and have it deposited either at the polling station or by any other means, with the only caveat of getting it processed before the polls close. So it's a risky game of being way too late on that. But yeah, I don't see a problem with that. And it is part of our usage and custom of the past. You're welcome.
I'll just say this as a sort of rhetorical question. It might have to do with processing of ballots within the guardrails and things like that. So I'm thinking that's why, when you're taking a ballot outside of the guardrails within that election polling place, you should not be taking regular ballots. So you take an absentee ballots. I think that's the rationale. I'm not sure that the RSA specifies that. It might specify that in the election law manual. Again, something for the election law committee to consider.
Yeah, I
but-
appreciate that. I think the level of concern is the voters. They've taken the time to come out even as far as they can, be whatever their situation. And when they see that it's an absentee ballot, they feel like they've been dismissed in such a way that it's not the official one. That's all I'm asking. If how does that play for their own particular situation?
So I think that's something that we should consider in the larger committee about how to properly address that aspect so that there are some, everyone here knows that I'm very passionate about the ability of people who have disabilities and other similar challenges their right to vote must be protected. And I think we just need to clarify how that is enacted in a way that they don't feel discriminated against or in some manner. So excellent line of questioning. Thank you very much. Representative Newsom.
Thank you very much, and I'd like to apologize to the subcommittee and our guests for my tardiness this afternoon. That's fine. I'd still want to get that on record. So, and I'm not sure if this really matters in the grand scheme, but in your opinion, when does an absentee voter technically vote? Is it when the ballot goes in the envelope and is sealed, or puts it in the mailbox, or when it's received on the other end? And I'm not really sure if it matters in the grand scheme. I'm just curious what your thoughts on that might be.
Yeah, no, I would say that the ballot has been cast once it's been received by the moderator. And then the moderator has a 3-step process. A, to make sure that the voter is on the checklist. That's the first step. B, that the affidavit appears to be properly executed. And C, that the signature verification is also in line. Now, I don't want to get off in the weeds, but we could have this conversation offline about Sauciato versus Gardner, where this went to the federal court and there was some hanky-panky that went on, and we'll take that offline. But yeah, it's been an issue. But that would be my answer to your question. So yeah, the fact that, well, and again, what I like about the affidavit process is that now it's been sealed and there's an eyewitness. So that when you go to check C, and this is what they didn't tell the federal court, is that you have an authenticated signature to verify. If you don't have a notary or an eyewitness to the inserting the ballot in the envelope, how can you trust the signature? The state brought in the ACLU brought in a signature verification expert who convinced the federal judge that moderators lack the skill set, the training, or professional capacity to discern to a certain degree to disallow a ballot based on the fact that the signature didn't match. Moderators don't have that skill. And I wouldn't disagree with that opinion, but they left out the important part, that if they did the affidavit, then the moderator would be looking at an authenticated signature. And we're no longer, we don't have that. That hasn't happened since 79.
Right. So the authenticated signature being the
Yes.
public notary, not the actual voter in this case.
Right. The notary verified that that was his signature.
Right.
So the moderator could trust it because he personally had an eyewitness.
Right. And part of the notary process would have been to confirm identity and confirm that all the other attributes for voting were being followed as,
I.e. different than what Representative Lane was talking about, which is an unsworn declaration. That's the legal term. And in some jurisdiction, it is permissible. And I would say that it would have to be done by the legislature in order for that to be done, but not the Ballot Law Commission. I'm sorry, Freudian slip. Not by the Secretary of State of the AG. Next I have for you, hopefully, the solution to your domicile.
So because there have been a number of questions, you're certainly extended beyond 3:15. The meeting is supposed to last till 4, so please continue, but don't feel pressure to end by 3:15. I want to extend as much courtesy to you as I possibly can, because this has been, I think, very informative, and I think the subcommittee greatly appreciates your testimony here today. So if you would continue, but I will advise you, you're on page 9 of 17, and it is 3:06. So I asked
I'll
you to
speed
do your
along.
best, and I know from your dog training skills that you'll be able to do this. So I'm
Absolutely.
confident in you.
All right, for you non-lawyers here, I'm going to close out on my point about the state Supreme Court. The court said the following: applying our standard of review based on the alleged facts, we determined that the plaintiff has sufficiently demonstrated his right to claim relief, and he's therefore demonstrated standing in his equal protection claim, and they cited several cases. Noting, and this applies to everyone, should all know this, noting that voters have standing to bring equal protection challenges to complain on vote dilution, and observing that, quote, many of the cases have assumed rather than articulated the premise of deciding the merits of similar claims. In other words, proving fraud is very difficult. And the fact that I went down this road is why I was able to convince the state Supreme Court that this should move forward. Because the trial court did not address the plaintiff's equal protection claim, we remand for further proceedings consistent with this decision. In doing so, we express no opinion on the merits of the claim. That's because the state Supreme Court is an appellate court, and so it didn't want to taint beyond the finding of standing. And again, for the non-lawyers, standing doctrine is layman's term. A good example is that there's an injury in fact, that I suffered some type of legal or concrete injury. Number two, the causation, that the alleged injury is fairly traceable and a challenge to the challenge conduct. And lastly, redressability. The court can redress the alleged injury if it grants the plaintiff the requested relief. And that's a closeout on my case. One of my favorite subjects, state citizenship. Not knowing the difference between state and federal jurisdiction has caused us all kinds of trouble, and I'm hoping to make it really simple for you here today. So that's the header of my third and final category today. Question number 3, question of citizenship. Citizen of the state of New Hampshire versus a citizen of the United States. What's the difference? And how does this affect voting rights and immigration, naturalization rights? Most people don't put the two together, but they're directly connected, and you'll see why when I get there. I'm going to quote an old case. It's one of my favorites. Susan B. Anthony was famous for women's suffrage, but she's also famous for another issue, which is her case in 1873, which I'm going to quote the U.S. Supreme Court on. The right of privilege of voting is one arising under the Constitution of the state and not under the Constitution of the United States. The qualifications are different in different states. Citizenship, age, sex, residence are variously required in the different states, or may be so. If the right belongs to any particular person, it's because such a person is entitled to it by the laws of the state where he offers to exercise it, and not because of citizenship of the United States. U.S. versus Anthony. The confusion for most people begins with the wrong understanding of the U.S. Constitution, 14th Amendment, which states, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Article 4, Section 2 of the U.S. Constitution provides, citizens of each state shall be entitled to privileges and immunities of citizens of the several states, citing U.S. versus Anthony. This right to travel and its protections afforded to citizens of the several states does not include the right of suffrage under the state or U.S. Constitution. So let me break this all down for you. What they're basically saying is that the 14th Amendment was a solution to the freed slave problem, right? So what did they do? The black codes and the black rules were excluding freed African slaves from their right of suffrage and to be treated like other state citizens. And so what happened for many years, I believed wrongly that the U.S. Constitution or the 14th Amendment created two classes of citizenship, one state, one federal, until I figured out that no, it didn't do that at all. 14th Amendment made very clear that if you are a citizen of a state, you're also a citizen of the United States, and then the rest of the 14th Amendment would apply to you, right? The equal protection, the due process clause, those provisions would apply to you as a citizen of a state. And whenever, from that point on, it's my opinion, from that point on, whenever you see the word citizen of the United States, you're looking at federal jurisdiction. key, because I pointed out Article 4, Section 2, the Privileges and Immunities Clause. And by the way, your right to travel under that provision deals with commerce, and it's articulated very eloquently in the Article 4 of the Articles of Confederation. And the Supreme Court has reaffirmed, if you really want to know what the Privileges and Immunities Clause says, read that, because that's what the Supreme Court says it should be, what its interpretation. And what does that mean? You have the protected right under the U.S. Constitution to travel anywhere you want. You can go from New Hampshire to California to Alaska to Hawaii unfettered. No checking at the border, and the right to be treated, for example, you're born in Massachusetts, you're a Massachusetts citizen by birth, but you want to run a business in New Hampshire across the border. New Hampshire has to treat you the same as its own citizens. It can't treat you differently. But guess what? There isn't. There is no case precedent. There is no provisions whatsoever where the 14th Amendment nullifies the Privileges and Immunities Clause. In other words, the Privileges and Immunities Clause, when you move from California, let's say you were born there and you moved and you want to go to school at UNH or Dartmouth or wherever, right? You don't automatically inherit the right to vote when you arrive here. And I'm going to use my personal story as an example. I was born in Canada, was naturalized in New Hampshire. When I joined the military, they shipped me to Texas. I was still a citizen of New Hampshire. And when I lived in Texas, I was a Texas resident. See, the words have been manipulated and flipped around, causing a lot of confusion. But I was a resident of Texas, residing there because of military duty, and I had to vote absentee in New Hampshire, just like the college kids should, in my opinion. And then when I was deployed to Europe, I was living in the United Kingdom for 3 years. I was a resident of the United Kingdom, but I was still a citizen of New Hampshire, and for federal purposes, a citizen of the United States. So this is the key to this change. And I found the evidence in the original 1808 law of New Hampshire, where there is the provision to make this all happen. Now, currently, this is really important part. The word inhabitant is defined by the Constitution in Part 2, Article 30, and it means specifically someone that possesses political rights. Article 30, when it was first written in 1784, before it was altered in 1976, said that all persons born or naturalized, I'm sorry, I'm quoting the 14th Amendment, it says, every person qualified and I keep flipping the two around. Article 30. And every person qualified as the Constitution provides shall be considered an inhabitant for the purposes of electing or being elected into that office where he dwelleth and hath his home. That's pretty close. So what does that word mean? In 1976, the state legislature did something it shouldn't have done. It posed 5 yes or no questions to the voters, and the domicile question comes to life. Now, I know for sure the meaning of domicile because there's a famous case here in New Hampshire called Newburgh versus Peterson. Newburgh versus Peterson, the backstory was a young man born in New Hampshire in the area of Dartmouth was went to vote, and he told the supervisor of the checklist that when he graduated from school, he was going to move to Hawaii. Well, they disallowed him casting his ballot. So he sued in federal court and won because they had no right, because he had the birthright. He was born here, and therefore he was a qualified voter by birth because of the immigration of naturalization. And the federal court had to figure out what dwelleth and hath his home means, because domicile doesn't exist until 1976. So they considered that, and the federal judge said that dwelleth and hath his home is an old style of English that means domicile. So why did I tell you that story? Because in 1976, they posed 5 yes or no questions to the voters. Question 1 was already law. The voting age had already been reduced from 21 to 18. Why is it the lead question? Question E. Absentee voting was supposed to be created by this amendment of 1976, which wasn't true because that happened in 1942. Question B and question D, one was the domicile question. D was changing the month from January to December as to when we're going to announce the outcome of the election. Those have been adjudicated already and have been struck down by the court. So Why did they go through all of this trouble to swap the word inhabitant and domicile? They told the voters that if you pass this, that we are now going to focus on domicile instead of inhabitant. And this was the beginning of the chaos, because they had done one other thing. They had removed 5 words from the word citizen of the United States from the original law. Quote, being native born or naturalized citizen of the United States. If you remove the modifying language in front of the word citizen of the United States, you would now be saying that you had they detailed the manner in which you became a state citizen. This was a big deal, because without it, if you're going to refer to a qualified voter based on his citizenship status, right, and you use the word citizen of the United States, that applies to all 50 states. Every person born in the United States can move here tomorrow, check into a hotel room, take that receipt, go register at the local new town hall, because you said a citizen of the United States. Well, that's every American who's been born or naturalized, because you weren't focusing on state citizenship. So if you're not going to refer to state citizenship, they started using the word residence, and they started using the word domicile. And both of them only declare one thing, that you live somewhere. The word reside, residence, or resident don't mean anything in anyone's dictionary going back to before the revolution other than you live there. But state citizenship, on the other hand, and here's the key point, under federal law, most people don't know this, under federal law, it's illegal since the early 1970s to apply a durational residency requirement in order to cast a ballot or to register to vote. So in other words, the state legislature is precluded by federal law to say, you got to live here for 30 days. Can't do that. But here's the hook. If you make it state citizenship, the state has its sovereign authority to define who its citizens are. This goes back to the beginning of the beginning of the Republic under the first Immigration and Naturalization Act of 1790. Won't bore you with all the details, but from that point forward, the states retained under their sovereign authority under the 9th and 10th Amendment the ability to retain their right to define who their citizens are. Now, this was in effect from 1808 all the way to 1973. And then it went away. 3 years later, we get the domicile question, and everything's been a chaos ever since. And the only thing we've gotten out of it is billable hours, because it just doesn't get solved. And we keep looking for solutions that don't. And so Article 38 of the Bill of Rights says that the best thing to do is to go backwards and to look at what was there before. So that is the issue on state citizenship, inhabitant defined. Now, bottom of page 10 is my first provision to inhabitant defined, and I'll run through the list very quickly. This court reaffirmed the definition of the word inhabitant in the following opinion of the justices in 1927. Same thing here, another decision. Every person qualified as the Constitution provides shall be considered an inhabitant for the purposes of electing or being elected into office. The state constitution says the same. Why do we keep in statute referring to people as residents and domicile when the Constitution requires the use of inhabitant? And with that, I need a break.
All right, well, are you able to continue after that break?
Yes.
All right, we'll recess for till 25 after, and then
Be right back.
we'll continue. We'll reconvene and continue to hear Mr. Richards' testimony. Just for context, we were on the topic of citizenship. I think this is of great interest to the subcommittee and perhaps the election law committee at large. So please continue. And thank you again for your time.
Thank you so much. Page 13 of my testimony. How to become a state citizen. This is the 1808 law. And what's fascinating about this chapter 49 is that it happened 18 years after the U.S. Constitution went into effect. So what's important is the understanding of how both the state and federal constitutions work together in this document. And so let me go through it. This was the original text. Be it enacted by the Senate and the House of Representatives in the general court convened that every male inhabitant of each town and parish with town privileges and places unincorporated the state, being a natural born or naturalized citizen of the United States, that's what I was alluding to earlier, of 21 years of age and upwards, again, 1808, women were excluded and you had to be 21.
And just to clarify, Mr. Richard, the underlined bolded text is your highlighting of that text. It was not in that original.
No, it's there. It's there for a special focus because that is what was modified by Representative Sanborn, House Bill 363 in 1973. He was concerned. He must have been a soldier. He was concerned that his children would have, without fixing what he perceived as a problem, that they would be impacted by being born abroad. And so that's why he wanted the language changed to citizen of the United States instead of a citizen of the state, thinking he wouldn't have the same protections. But he didn't know the immigration policy, which was if you are born in the United States like John McCain or Ted Cruz, right, and then you're born of American parents while deployed for any reason, or it doesn't matter as long as your parents were Americans. But anyway, that language was removed, being a natural born or a naturalized citizen of the United States. When I first read this, I was confused. I said, if the federal government under Article 1, Section 8 of the enumerated powers for the federal Congress gives them the responsibility to naturalize people, what are they talking about in a state statute? And then the following chapter gives us the answer. 21 years of age and upwards, excepting paupers and persons excused from paying taxes at their own expense, shall have a right at the annual or other meetings of the inhabitants of said town and parishes to vote in the town or parish where he dwells and hath his home. There's that language again. That no person shall be considered an inhabitant in any town, parish in the state for the purposes of voting unless he have resided in such a place for 6 months or had become a freeholder. That was common practice to be holding land and having resources. Now, here's the part that I think that we can incorporate into the legislature now to fix this problem. And I think I sent you a copy of, I'm consolidating 50 chapters of election law into 5.5 pages. I did it 3 years ago, and I got Bill Gardner. He loved the idea. He says the only problem, Dan, is politics. Neither party is likely to let you move this forward, but there wasn't an appetite to fix the problem then, and that's where the affidavit ballot came from. I work with the various people on that. But this is the solution right here. Section 2, and be it further enacted that no person not being a citizen of this state, that's very clear, of the state or of the United States shall be entitled to vote at any town meeting for the choice of state, county, or town offices, unless he shall have resided within the state for 2 years and shall have made an oath before some justice of the peace or other person authorized to administer oath, that he will bear faith and true allegiance to the state of New Hampshire and to the United States, and will support the constitutions, plural, constitutions thereof, provided, however, and they repeat themselves, that no person not a citizen of this state, of the United States, shall be considered qualified to fill any county or state office. The rest of it is there for your reading pleasure. I won't bore you with any details. That was the point I wanted to make, that The key is, and by the way, the 2-year durational residency in this law in 1808 was in harmony with the same durational residency for immigration at the federal level. So they adopted the same policy. If we were to adopt it here, it could be, I know that there's talk about college kids and in-state tuition, right? When are you eligible? And I believe the rule used to be you had to live here for a year before you'd be entitled.
Just to clarify, we actually heard testimony from Mr. O'Brien earlier today from America Votes that actually the current criteria is at the time of admission, and that is their status throughout their duration at the college. So, if they're in state at the time of admission, they're out of state at the time of admission, regardless of whether or not they change residency state-wise. So I would say also, I would say for some people may think that this taking an oath to and with allegiance to the state of New Hampshire and the United States might seem archaic, and but that is exactly the same oath that all representatives, senators, governor, et cetera, take when we're sworn in. So this is not really an unusual practice or an outdated practice. It's something that all your elected officials are required to do at the time that they become accept that election result and become an elected official. So, any questions at this point on? All right. Were there any other? So I thank you for highlighting that. Let me, if I could just ask a couple of questions.
Yes.
So if someone, how would you handle this? So suppose we have what we refer to as snowbirds who live in two places, southern climates. I'm not talking Massachusetts, but Florida and the Carolinas or something like that, and people who are up here a portion of the year. If under this scenario, if you had, I'm asking a hypothetical, so I understand that as well. If you have someone who were to take such an oath to be a citizen of the state of New Hampshire, and then they decide to, while maintaining a residence here in New Hampshire, also obtain a residence down in Florida, at that point, I don't see any problem if they maintain New Hampshire as their primary residence and they take a temporary absence and visit Florida occasionally. But if they conversely move to Florida and while maintaining the New Hampshire residence, but then get a driver's license, establish that as their primary residence for federal tax purposes, for minimum required distributions of 401ks, et cetera, how would you handle that scenario? What is there any? Have you thought about that?
I have.
Oh,
Yeah,
great.
the
Awesome.
answer is straightforward, and that is that this is where this state citizenship solution is really a great idea, and that is that if you can swap state citizen with domicile. The effect of domicile, domicile is elective franchise. You elect to declare a domicile when you choose to move, right? And by the way, back on the oath factor, that was in effect until 1973. In the last QVA, before these modifications came to be, that's what was in place, is that you declared that you met the durational residency requirement to become a citizen of the state. And so let's walk through it from my perspective, the college kid or the other person. As I said earlier in my testimony, I was naturalized here, so I became a citizen of the state, moved to Texas, where I was a resident, but I still had to vote absentee in New Hampshire because I wasn't a citizen of Texas. The same when I went to the UK for 3 years. Now, college kids, same thing. A college kid born in California has automatic birthright in the state where they're born, and they are citizens of the United States under the 14th Amendment. If they move to New Hampshire, the process used to be the state citizenship route, but it got changed to a domicile. And what I found that I spent some time with attorney Brian Gould and Bill Gardner about how disappointed they were with SB 3 collapsing on itself. And I thought to myself, yeah, if anyone had done their homework, they'd have figured out, why are you attaching durational residency requirement when it's prohibited by federal law? Because the GOP spent all of its time trying to define all the things that apply to a state citizen, but make them stick to a resident. And it's the same with statute 20 in the statutory construction, 21.6 and 21.6a. 21.6 commingles inhabitant and resident together. Well, how are you going to do that? If the Constitution says you got to be an inhabitant, but the statute says that an inhabitant or a resident who establish a domicile. Well, here's a little trivia for you. How many times is the word resident used in the state constitution? Once. And it's not in the Bill of Rights. It is in contradistinction to the word inhabitant. Same with the word reside.
Let me ask a clarifying question, because I want to make sure I'm sometimes slow on the uptake. So you're saying that, in fact, inhabitant is distinguished from resident?
Absolutely. It has a constitutional definition. And I would argue in 1976, what was really afoot with the domicile game was, prior to that, it was well understood. I have a long list of the definitions of inhabitant. I read a couple of lines. The rest of it is there. It's like 30 different places where the word inhabitant is defined by the Constitution. And what the legislature at the time didn't like is that voter qualifications were defined by the Constitution and not the legislature. So the domicile game became, well, if we use the word domicile, someone establishing a domicile, the legislature gets to define what those qualifications are, where it shouldn't be. Imagine your employees, you start a company and you write an employment manual on how to elect more or how to hire more employees. Freudian slip, sorry. But what happens is, and then all of a sudden, the manual that you wrote on how you want your employees, the qualifications you want for anyone working for you, and now you change it. And now your employees, that's the problem, right? The elected class, Article 1, Section 8, our representative body, are now deciding how they reelect themselves. That's what's flawed about that line of logic. But I digress. Did I answer the question?
Yeah. Yes, I think so, because if I'm understanding, there's almost an implicit conflict of interest if we remove the voter qualifications from the Constitution and put it into the RSAs.
Right. Do what the Constitution doesn't provide. If you study the amount of times the state constitution has been amended, you'll find in the 19th century, from the 18th into the 19th century, there were relatively few changes until we get to the 20th century. I'll give you an example. The Department of Education. In 1850, the state legislature proposed 12 amendments to the state constitution. And of those 12, I'll focus on 5. They wanted to get rid of the executive council. That's amendment number 1. 2, in its replace it with a lieutenant governor. Number 3, create a Department of Railroad. Number 4, create a Department of Education, create a Department of Agriculture, and 7 other things. They woke up the next morning and the people said, no, we're not giving the state government any more power, because that's what Article 1 says, all power. We are a constitutional republic that uses a democratic process. But we've started acting like a democracy in the last few years, where a majority rule of either party leaves legislation put in place that's passed along political lines that is not in harmony with the Constitution. Because that is ultimately our constraint. That is the limiting governing document in all of this. If that's good, I'm going to move on to the next piece. Federal law, U.S. Code, Title 8, Aliens and Nationality. I'm going here to point out.
Help us with the page number.
Page 15.
Thank you.
U.S. law defines under definitions 1101, the term naturalization means the conferring the nationality of a state upon any person after birth by any means whatsoever. Back to the state citizenship point, right? Right. Understand, because again, we have concurrent jurisdiction. We must be mindful that we have a state constitution and a federal constitution, both of them which have effect on the election process. Now, state constitution, Article 11. I put this, I found it fascinating that it was one sentence in 1784. Today, it's a page and a half. The first Article 11 controlling our elections in New Hampshire. All elections ought to be free, and every inhabitant of the state having the proper qualifications has an equal right to elect or be elected into office. That was June 2nd, 1784. Today, it's long. So I highlighted the relevant points. Article 11, an elective franchise. All elections are to be free, and here's that word, and every inhabitant, not resident, of the state, 18 years of age and upwards, shall have an equal right to vote in any election. That is another constraint on the committee, both sub and committee of the whole, is to please pay attention to that point. It's reaffirming itself. And then down at the bottom, absentee voting. Now, I testified last time that during the Civil War period in 1863 was the first time the state legislature considered absentee voting because of the Civil War. And the Supreme Court said, no, the legislature has no authority to establish any exemption for absentee voting. Next, 1921, World War I, same questions, same problems, same people. Supreme Court said, we told you 50 years ago, you have no authority by statute to create a new exemption to vote absentee. So that leads to 1942. Where they actually go ahead and do it. And that's part of the record here along the list of exhibits. I've got 7 exhibits for you to review. They're made up of the original amendment and the subsequent changes. And, but yeah, 1942. So I would argue, and I did argue, that if it took an amendment to the state constitution to permit the 2 provisions that exist because you'll be out of town, or 2 that you're physically disabled, I would say that in 1979, when they created by statute a religious exemption, that was wrong, and that's how the notary certificate went away. See, you only had 2 exemptions. You had physical disability, I'm out of town, I'm physically disabled, and the notary certificates, right? Well, now if you're going to add a 3rd exemption, now a new set of instructions for the Secretary of State came to be. And that's where the defect came to be by omission, because it's part of the record that I've left for you, is that that's all they did. And it wasn't the recodification either. It was they recodified all the laws, and the affidavit process stayed with it, like Secretary Scanlon testified to. But that's how they made the notary certificate go away. It wasn't a thoughtful legislative process, and now has left this deficiency. But let me read you what it says. The general court shall provide by law for voting by qualified voters. I interpret that as people who are already registered to vote. Qualified voters who at the time of the biannual or state elections, or of the primary elections therefore, or the city elections or the town elections by official ballot, are absent from the city or town of which they are inhabitants, or who by reason of physical disability are unable to vote in person in the choice of any officer or officers to be elected upon the question submitted at such election. And then at the bottom of Article 11, every inhabitant of the state having the proper qualifications has the equal right to be elected into office. Repeating Article 30, that inhabitant applies to those who want to vote, defining those who possess political rights. That's what the word means. And it's defined by the state Supreme Court in multiple cases. Now, closing out. Qualification clauses, U.S. Constitution, is Article 1, Section 2. The House of Representatives shall be composed by members chosen every 2nd year by the people of the several states. That phrase right there, I can tell you with great certainty what it means. The people of the several states means the citizens of the several states. And that opinion comes from Dred Scott. For those of you in this committee who don't know the case, Dred Scott is a racist decision, a black eye on the U.S. Supreme Court, where they said the Constitution only applies to white people. And so that's why part of what the 14th Amendment was all about was to solve that problem. But either way, that's what it means. And the electors, and that's why they refer to this as the qualification clause, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. This is where history is important. In 1784, the Senate was the first chamber in the state government. It was not the second as it is today. So you find all of the election provisions in the Senate and not the House when it was inverted. So a lot of people who try to do their own homework run into an obstacle there. But I wanted to point that out to you. So so basically what they said was the Senate rules are the rules for election process. And by the way, the same applies for the House of Representatives. So that's why the Senate rules govern how we elect senators and U.S. congressmen. Any questions on that? Did I lose you? It's a lot. No? Okay. All right. And then no person shall be a representative who shall have attained the age of 35 and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant. In other words, you can't hold political office in two places. So you can't be a member of the House of Representatives here and be a U.S. congressman at the same time. Article 1, Section 4, and this is a big deal, times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. This is where the Ballot Law Commission gets into trouble. I know I'm off track, but this is why it can't make law. It can't make rules and regulations for an alternate method of counting other than that which the legislature has prescribed. And this is reaffirmed by Moore v. Harper. But that's the point here. I also included, remember I told you earlier, durational residency, that's 52 U.S. Code 10,502, residency requirement for voting. No citizen of the United States who is otherwise qualified to vote in any election for president, vice president, shall be denied the right to vote for electors of the president and vice president or president and vice president in such election because of failure of such citizen to comply with any durational residency requirement of such state or political subdivision. Again, this body and the legislature can't say you got to live here for X amount of time if it impedes on your right to vote. You can do it for citizenship. You can define that you've got to live here for X amount of time before we're going to allow you to become a state citizen, because that carries forward under the common law under Article 90. But for this case, that's what it's talking about. Now, lastly here, voting rights. 10,101. And this is what's wrong with the affidavit problem as we look at it today. No person acting under color of law. For those who are not lawyers, that's the illusion of government authority. Okay? Operating under color of law. In determining whether any individual is qualified under state laws or law to vote in any election, apply any standard, practice, or procedure different from the standards, practices, or procedures applied under such law or laws to other individuals within the same county, parish, or similar political subdivision who have been found by state officials to be qualified to vote. That's the big federal prohibition, right? That you can't have two different sets of rules in the same town or voting district. Danville just had a case go to the Rockingham County Superior Court. There was a challenge where the moderator wanted to do a separate count to verify his certification to run parallel to the machine count. And the state Supreme Court upheld this, not the Supreme Court, the Rockingham courts upheld this principle and said, that's right. If your town chooses to use a machine, you got to use a machine. You can't do both. Can't be hand counting and machine counting at the same time because you have two different ways of doing it. So that's the recent decision out of our Superior Court, out of the Danville decision, and that brought that question forward.
Not to get too sidetracked onto the Danville case, but was that because we had the larger committee heard some testimony about a similar subject recently, and were they doing that in parallel, Or were they?
That's what they were trying to do, and I believe that is their testimony. And the court, in my opinion, I read the decision, they were right on their conclusions, but they got to it, in my opinion, a wrong way to get there.
Yeah.
But either way, we're still of the same mind. And that is that you have to have, and again, back to what were they doing to the freed slaves back in the day? They were applying different practices, procedures, and policies to disenfranchise them. And so this carries forward. And finally, another part of the criminal penalties, and this deals with the lack of certifying the absentee ballots. Knowing criminal penalties. Number 2, knowingly and willfully deprives, defrauds, or attempts to deprive or defraud the residents of the state of a fair and impartially conducted election process by A, the procurement or submission of voter registration applications that are known by the persons to be materially false, fictitious, or fraudulent under the laws of the state in which the election is held. Or B, the procurement, casting, or tabulation of ballots that are known by the person to be materially false, fictitious, or fraudulent under the laws of the state in which the election is held. These federal issues the state hasn't touched and doesn't want to touch because they lose. So they're not answered, so they've avoided this until Secretary Scanlon opened that door. But either way, that's what I'm arguing in my case. And look, my position is simple. The Secretary of State has the benefit of legal counsel. How do you do this wrong? How do you not know that there's a problem, there's an affidavit problem, and you write a new solution with an election procedure manual? And so that's something that you guys will have to take up at your own speed. That's your business. And I also, there's another document, I'm not going to read it to you now. The bottom here on its header, criminal interference with state and federal elections. When the state Supreme Court remanded my case back to the trial court, the trial judge, because they didn't address the equal protection arguments that I had raised, went ahead and gave the state defendants a seventh bite at the apple to brief the equal protection issues. And when they did so, I pointed out that you're violating federal law. That's where my allegation of criminal interference, and I'll let you read that, but that is now before the Rockingham County Court. We're waiting on that decision to move forward to a scheduling conference. So.
Very good. So Representative Lane, you have a question.
I just want to make sure that I understand the state citizenship piece
Yes.
versus the, I know it's not called resident, domicile requirement, the length of the years.
Yes.
So I just want to make sure that, were you suggesting that you could perhaps get around that requirement by putting it in the requirement of state citizenship that you had to live here? for 4
Durational
years?
residency under the sovereignty of the state, under the 9th and 10th Amendment, and the original naturalization law still has that authority to do so. They can say you need to live here for 30 days, 60 days, a year in order to become a citizen of the state. If you use domicile or residency as qualifying language, if you're going to write that into your statute, you cannot use a durational residency test under the federal law.
That's why I was asking the question. I just wanted to make sure I
Yes.
understood. So where in, and I don't know this, where are the requirements to be a New Hampshire citizen laid out in our statute?
Chapter 49 that I read to you earlier, the original 1808 law, and
Okay.
I gave you the consolidated, updated version to include women and the voting age down to 18, and I can put it all together. And in the definitions chapter, which is key in my work that I sent you, has all the proper definitions written there based on the historical context.
I have one more question.
Well, I just have a quick question related to that answer.
No,
Okay.
no,
Go ahead.
I just want to make sure.
Representative Lane.
On page 10, when you were reading the, down towards the bottom, the citizens of each state shall be entitled to all privileges and immunities. Did you say that the citizens of the several states does not include? Because it says does include.
Well, the privileges and immunities clause involves all citizens of the several states. So that is your right to travel, and it does not include elections. There's no,
Okay, so the word not is it's left out, I think, in when I'm reading.
And I
it.
may have goofed in a hurry to get this all
Okay.
done. So please forgive me if there's,
No, I just wanted to make sure I heard you correctly. Okay, thank you.
you're welcome.
That's it.
And the only other thing that I had, go ahead.
Representative Newsom has a question. I'd like to
Thank
entertain
you.
his
Yeah.
question first.
When Representative Lane asked you about the statute to become a state citizen,
Yes,
you referred to the law in 1808
Yes.
that you handed out.
yes,
Are you aware that that act was repealed less than 6 months later?
yes,
Is there a current definition?
yes.
In what section would that be in today's RSAs?
Let me back up and restate my answer.
Thank you.
It existed from 1808 till 1973. And in 1973, that was removed. So the process, the QVA was the last evidence that was in the 1950s. In the 1950s, chapter 50 and so on, forgive me on the numbers, but whatever came from the 1950s lasted until the 70s. And that's where that language went away about being a citizen of the state, because now we're referring to citizenship as national citizenship by removing those words native born or naturalized. So you're right. It doesn't exist in statutes today.
Okay, so if we were to go down that route and use that, we would then need to reinstate that as part of it?
The old policy, correct?
Yes.
Yes.
And sorry, one more follow-up on this. Do any other states use a state citizenship standard?
I
currently?
haven't cross-referenced anyone currently, and I don't think they do.
Okay, thank you.
And I believe that the start of all of this starts in Tennessee. There was a law professor who moved to Tennessee. He was taking a job at the university there, and they had already changed their language to residency as a prerequisite. And so he went to register and was denied the right to vote, and he sued and won. It made it all the way, I think, to the federal courts. And he said, hey, I'm a new resident. Why does an old resident, why am I being disenfranchised? Because why are you treating me differently? We're still focusing on the word resident. And word resident, based on state statute, gets applied based on what the legislature has decided. So that's the problem. That's where all of this really stems from, is we stopped focusing on state citizenship. And from that point on, if we're not going to refer to someone as a state citizen, we're left with only two other words: residency or domicile. And that's what we're using now.
And just and no other, are there other states that are using this domicile aspect? Do you know about that?
I believe almost all of them are.
Okay.
All of them are, because again, if we're not, and I think that this should be a 50 state solution, not just one state, because if we finally get to that, my solution to anyone who is here temporarily going to school or otherwise is you still get to vote absentee. And we do need to do a better job at making sure that they have those provisions, especially for our citizens who are deployed elsewhere, because that's where absentee voting really came to be in the first place, is to address deployed veterans and those supporting the war effort.
Representative Burnham.
Thank you. So going back to is it 1973 or 1976? I'm kind of,
There's three events: 77, 79, 77, 76, and 73. Which
okay.
one?
So 73, I believe, is the last time it was, or that's the year
Yes.
it changed for the state citizenship.
Correct.
Okay, so was it before that, were voters required to show a state citizenship document? Is there a documentation they would have shown to vote?
The law, the 1808 law, chapter 49, ultimately is modified to the point that by the time we see the last evidence of state citizenship is at that period of time, and they did so, lost my way, 73 on the...
State citizenship, if they
Oh,
had
the
showed
QVA, there it is, the QVA. So the QVA that we have today, the qualified voter affidavit, was something to the effect that you swear to the fact that you have met the durational residency requirement to become a citizen of the state. And that went away. When that went away was all part of these changes in the 70s. And that way we were now focused on domicile and residency as the focal point for legislation, establishing that as the basis And I've also attached in these exhibits, I've also given you the voters' guides.
And I just have a follow-up. Do you know if what s- state residents would have to do in order to vote? Say they moved, previous to 1973, moved to New Hampshire for voting, they would swear at the same process, or do you know if was a different process with new people moving into New Hampshire?
From what period are you asking me about? The period when it was in effect?
Prior to 1973, what was the process for them to vote if they were new? I don't want to say residents, but new citizens of New Hampshire.
They wouldn't become a citizen until they had met the durational residency requirement established by the legislature to be a state citizen. And once that went away, now you're dealing with the federal law on durational residency for voting. You can't go there for voting. If you go there for voting, you get in trouble.
Okay.
You're welcome.
All right, I think,
I got one more thing for you.
okay.
Federal law. And I'll wrap up real quick.
Very quickly.
You asked me about the Bruin decision. So what's
Yes.
happened is the U.S. Supreme Court in the Second Amendment case took on this perpetual problem of the Second Amendment. And what they've done that's radically changed the landscape is I know that the attorneys will get this, they've abolished means ends scrutiny. Means ends scrutiny from a layman's perspective is that the courts for the last 60, 70 years have been applying a balancing test when they examine any proposed legislation that is being there's an allegation that it infringes upon any of the rights. So the Second Amendment's been back and forth. And what the Supreme Court said, look, why do we treat the Second Amendment different than the First Amendment, than the Confrontation Clause in the Sixth Amendment, or the freedom of religion? So it addressed 4 other issues and it said, look, from now on, we're abolishing means end scrutiny, which is 3 different levels of a balancing test. In other words, the judge would say, all right, we have the Bill of Rights here, but we have the public interest here. And so how much should anyone tolerate public policy infringing upon your rights? And so they said, you can't do this anymore. From now on, whenever a legislative act infringes upon any of the enumerated rights, the burden of proof shifts from the people to the government to prove their statutory scheme was permissible when the Bill of Rights was written. Let me give you an example. In 1791, there was a Militia Act, and the Militia Act required that all able-bodied men had to carry a musket, gunpowder, and lead, and that they had to be 18 years of age. So today, it would be permissible for the state legislature to say, open carry of firearms, you got to be 18. Why? Because they could point to a historical analogy of going back in time and saying in 1791, it was permissible to restrict gun ownership in public to people who are 18. And so this is now morphed into the examination of all of our rights. And I also quoted another case that just came down this summer, which is the NAACP case. The NAACP of South Carolina accused the South Carolina legislature of being racist. They accused the whole body of being racist. Clarence Thomas writes a concurring opinion with the majority, joining the majority, that now ties the federal elections clause and the Second Amendment case of Bruin Heller. And so there wasn't that bridge, as the attorneys will tell you, is that in order to have precedent, you have to have a case that moves into the court. So right now, those Second Amendment cases that I've just talked about and those federal decisions, that decision now creates a bridge, in my opinion, that didn't exist, because that would only apply to the federal Bill of Rights. It wouldn't apply to the state because it's not state case law and it's not a state issue, even though there may be a correlating event. But either way, that's the point that they made. So from now on, when we look at dealing with those issues, and again, it's because election law is concurrent jurisdiction with both the state and federal constitution. So I believe, and those documents, by the way, are what I called late authorities. The Supreme Court has a rule, because it takes such a long time to go through the process. They have a rule that permits that any decisions of SCOTUS or of our state Supreme Court or of the legislature that comes down the pike, that they can be added as a late authority. And I did submit 3 of them, and I've given you 2. And that will lay out the boundaries at your own leisure to understand what those federal boundaries are as to how to legislate here in New Hampshire. What are those constraints? Like I said earlier, the 2 constraints are your state and federal constitution. Other than that, you're unlimited in your problem solving. I know some people don't like hearing that, but it is true.
All right, with that, I will thank you for your testimony and for, I'm sure you could have talked for hours more, so I appreciate.
This all lives in my head, just so you know.
I'm sure that's an interesting place as well.
What's that?
So,
Right.
so thank you very much. That concludes our testimony today. We're not taking anything other. There are some matters that we do need to discuss. Just some logistics here, I'm sure.
Please forgive me for this was not proofed. And if you need it redone, I'd be glad to resubmit it. And if there's any mistakes or further questions, don't hesitate to reach out to me.
Can I actually just get another copy of the packet that you gave?
Yes,
Just for
yes.
filing purposes?
I
Thank you.
know Representative Weary has the best copy. I think I gave you a good one, but if you focus on his, and some of
Okay.
this got broken down, that's what delayed me at the print shop. I was
Ah.
working with someone who was less than skilled.
I think it would be good to have it for the record as well.
Yeah,
Just have a
sure.
copy. Thank you.
Absolutely.
I've
yes.
already marked up mine, so it's
Ah.
not going to be good.
Okay. I will hang, so I have that here, and I will figure out a way to make sure we get copies of this. Upstairs, yeah, and they can make some copies, okay. All right. Okay.
Thank you all for your time. It's been a pleasure to sit down with you. I'm very, very grateful and appreciative for this opportunity. So thank you again.
Thank you. Go ahead and hit that button again. Thank you. All right, so just a couple of matters of house cleaning. Representative Lane did have some follow-up questions to one of the memos that Mr. Allen provided to us. I have forwarded that email to Mr. Allen, and he will respond in due time according with his excellent responses as always. So we appreciate that. We appreciate all the research that he's been doing on behalf of the subcommittee. I think also, I want to reiterate something I said at the beginning. We had on the public notice that House Bill 608 would be part of today's working session, but due to some errors that had been already execed. And so we are not doing any action on that today whatsoever, though we did hear some related. What's that? To be honest,
The computer whiz over.
wait. It's requiring moderators to inspect absentee ballot affidavits for full execution. I honestly can't remember. I'm sorry. We've had 75 bills this year in election law, and so it's keeping. I've got kind of not alphabet soup, but number soup in my brain right now. So,
Gained newfound respect for the chair you're sitting in when I watched the last hearing, going through all of this work, seeing how it's working. Wow.
I've got 608 here.
608? I have it as ITL in my notes.
It was
you have ITL.
the ITL that, and put it on the consent calendar.
All right, so I believe ITL was the outcome of 608, and that's why this committee is not subcommittee is not working on it. So I just wanted to, that was part of the opening discussion or opening points, and I just wanted to reiterate that to make sure that that was understood. We are on a a pretty aggressive timeline because I think crossover day is the 27th, whatever that last Thursday in March is. Hang on just a second. Let me just check that. Yeah, 27th. So, and everyone saw the note that we might be meeting for a house session on the 26th as well. Just keep that in mind. Yes, of course. So I wanted to, yes, we are. I want to just say, I will be attempting to put together a report over the next several days. And as soon as I am done with that, I will get it to this committee. My goal, ideally, is to have it done. Yeah, it's going to have to be soon. So to get it done early next week, so that we may discuss it as best we can on the 14th. That still gives us a little time. We're not obligated to make actions on every bill because the larger committee can do that independent of us. So the larger committee is certainly not beholden to the subcommittee. It's the opposite. So, as proved by HB 608. And so, we may not take action on every bill that we've identified as being before this subcommittee, but I will try to some degree acknowledge each bill that was originally listed and say what was the aspect that was germane to the subcommittee's interests. I'll try to include that in the report, and my goal is, again, to try and get this to the committee by the 11th, at least a fairly decent draft, and then we will have further discussion on the 14th. And the minority party is always welcome to submit a minority version as an addendum to the report. So, and we will include Mr. Allen's research memos, as well as this testimony. If I have time, I will also try and capture a few of the salient points of testimony from the various people that we've heard speak, which includes Secretary Scanlon, Deputy Secretary Hennessy, Mr. Clementowicz from the ACLU, Mr. O'Brien from on behalf of America Votes, and of course, Mr. Richard. So I will not try to summarize Mr. Richard's testimony, but of course he has his own summary. So we'll include that, and those will be addendums or attachments to the report as necessary. So those are the my sort of main thoughts. I want to discuss actions or whether or not we need to take any actions on the remaining bills within the subcommittee, and I want to discuss the aspects of the report and any other comments. I welcome comments or responses to what I've just said. Representative C.
I was just wondering, were we going to try to come up with recommendations for correcting the bills that are in front of us, or just try to summarize the areas and whether or not we should be coming up with an overall solution, possibly as legislation for next year?
That's an excellent question. I do think it is, yes, all of the above. So I think if we have opportunities to do something in the short term, I think we certainly want to do that. If we want to take a longer term solution, and I use this merely as an example, citizenship within New Hampshire, that is certainly not something, that would involve CACR, it would involve changes to the RSAs, it would require a comprehensive approach, and it would require a lot of coordination between our Secretary of State, the people on the other side of the wall, and the Attorney General for certain. Yes, thank you very much. Thank you on behalf of all the lawyers. Yes, thank you very much. So we certainly need to keep that in mind for any long-term solutions. So I don't think that what this committee could do is comment perhaps in the report on possible long-term solutions, and really just make notes of what I said. I think then it is up to the chair or individuals, it'll be up to the chair of the election law committee if he then wishes to form a subcommittee to further review that aspect, pursuant to what was done last year for the finance aspects. So I think it's really would be up to Chairman Barry at that point, but it's certainly within the purview and the mission statement of the. Oh, and I forgot to read the mission statement earlier, but it's within the purview of this subcommittee to make those sort of recommendations. I think if there is any short-term recommendations, those should be with, proposals to changes to the RSA or the bills, amendments to the bills that we have before. So if anyone has thoughts along those lines, let me know. Yeah, Representative Lane.
I'll give Representative Newsom credit for this, but when we were talking in the break, one thought we had, because we've got all this information and we're missing the Attorney General's information because they can't come in. And I just think that's really critical when we make our recommendations. So he suggested maybe we retain a lot of these bills, or retain some of them with the idea that we would be, because some of them are kind of on the same topic. So do we retain, because that's kind of what we did in the campaign finance one, is that then we spent the summer, God forbid, I'm sorry everybody, but spent the summer and fall working on those bills, and so that they were able to come in with amendments and really thought out and worked on and very comprehensive, and because this is a big big issues here, and I hate to feel rushed, and that's and we learned a lot today, I think, around the absentee voting piece, and I know that, and I'm not even sure if any of these bills really touch on that custody piece that we have. I don't recall. But anyway, that would be my thought.
And I think just along those lines, and I think Representative C, you had kind of touched on that idea about retaining some of these as well. But especially in consideration of the ACLU case and Mr. Richards' case, that I'd hate to kind of go out and do a couple RSAs now and then have the legal framework within which we need to act kind of pulled the rug out from under us and be in the same exact area next year. Although I know it's always a moving battle, there'll always be court cases, but I think we may want to let the dust settle from last year's amendments, and I think retaining would give us that opportunity to let that dust settle, take a holistic approach to all of this. Because I think from my point of view, while and correct me if I'm wrong, with the mission kind of started out as a non-resident voting concept, but I think a lot of what we've talked about and heard and learned is that it really is coming down to two classes of voters. and we need to kind of bring everything in a line to one class. And I think that I think it kind of misses the original intent, but I think it was the right path to go on. And I think that retaining some, all, most, I don't have an idea yet on which ones to kind of keep around for that, but to then have it as a study to really get a holistic approach for everything might be just as a suggestion.
Thank you for that, Representative Newsom. I think so first of all, we have no power to retain, but we can make that as a recommendation. So so I just wanted to clarify in case anyone listening, I have no illusions of power. I just want people to understand that. So, but I do think that there are some, obviously some merits to that. We want to think through this, and we want to, I think we want to improve things, but we also don't want to create a lot of double work where we're fixing something this year and then fixing it again next year and then the following year, if we all are elected, fixing it one more time, or choose to continue to inflict this upon ourselves. So, Representative C.
I was just thinking that one of the things that we probably should talk about is IDs, because that's one of the things that seems to be more urgent than a lot of other things. And I thought it was interesting what the gentleman from ACLU was speaking about. In particular, if a person doesn't drive, he doesn't need a driver's license. And in fact, if there's no other issue, he doesn't need any kind of photo ID on him. And it's not a requirement to live in the state to have an ID. But he still should be allowed to vote. That's
Right.
And that might help.
Yeah, and right, and there is a non-driver identification that the DMV provides. I think that is something that is a current capability. We are not, if we pursue that for identification purposes for those people who are not driving, that is not, we're not asking for the DMV to take on a new capacity. It's something they currently do, I think, and that has some merits to consider. But so you have follow up, Mr. Representative.
as a follow-up on that, it may be that we might want to specify certain situations where the fee for getting the non-driver's ID is waived.
Yes, I think that makes sense. We certainly do not want any perception of that to be the proverbial poll tax or anything like that. But I think the key is that no voter is overly burdened. I think that's certainly what I have seen from the court cases that we've been that have been identified to us. So, any further comment, Representative Lane?
I was just going to say, I think that might be the kind of in the report when it comes out, is that we kind of look at those, because we heard that for purposes of just identifying who you are, any kind of picture that shows that you are who you are may be acceptable, but it may be different in different circumstances. And so, and that might be something that comes out of the report, and we could maybe amend those statutes and kind of do those if we want. If not, retain them. I mean, I'm not, and I had another thought, but I don't remember, because I'm getting really tired. We had an interesting meeting earlier today. I think I'm about to hit the wall, so,
Oh,
okay.
All right. Well, Representative C.
You mentioned one word that just caught my ear was overburdened, and I just thought about people standing in lines because last night I stood in line for over half an hour to vote at my school district meeting. And it was interesting because everybody in the long line was from my town of Loudon. Everybody else, they were going out and saying, anybody from any of the other towns, there's no line at your station.
Wow. Wow. Okay. That's, yeah, I mean, that is something that election law and the municipalities certainly have to wrestle with. We do not want long lines and our voters to be burdened by that aspect, and we need to really, but that's not merely an election law problem, election law committee problem. It is a problem for the wards to consider. Let me go around and ask for any final comments. Representative Newsom.
Not at this time.
Thank you very much. Representative Burnham.
I am overwhelmed with some knowledge. So that is my comment for today.
Thank you very much. Representative C.
I think my brain's full.
And Representative Blade.
I'll join that chorus. I will let you know that at the request of our chair, I went through 385, which was my bill that was undoing 1569. And I found a couple of things that should have been omitted, and I put in to OLS to do an amendment. But I do have copies of what I sent to them so that y'all could see, what I was doing and what I changed. So I have those, and I think, yes, that would be it.
Okay, well, thank you very much. I will, as I said, I will try my best to have some sort of decent report for people's review early next week. Early meaning, kind of at the latest close of business on Tuesday, or maybe end of day on Tuesday. We'll see how successful I am at writing. And then we'll certainly plan on meeting on the 14th. We will discuss on maybe if we could just have some offline discussions on Tuesday about your availability the following week in case we need to do a quick meeting or two, just to, if nothing else, to refine the report, or to, if we feel that there is an RSA that we want to amend, what to do there. So with that, I will gavel the meeting closed. We only went till 4:30. It's the efficiency of this crew here. So I appreciate that. Thank you so much. And everyone have a wonderful weekend.